I doubt it.
If I had a choice, I'm trying to see why I wouldn't be watching it. But with that note, let's call this meeting to order. And Ms. Matlock, if you'll read the public disclaimer into the record and then call the roll.
Notice of the January 12th meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 19th, 2021. Additionally, this month's agenda has been posted on the website since Friday, January 5th, 2022. And next, I'll call the roll. Commissioner Steve Glenn. Here. Commissioner John Moffitt. Commissioner DJ Ferris.
Here.
Commissioner Joan Smith.
Here.
Commissioner Stacy Torbett.
Here.
Commissioner Jeff Diaz.
Here.
Commissioner Joe Begley.
Here.
Vice Chair Marcia Franks. And Chairman John Grace.
Here. We have a quorum, correct?
We do have a quorum.
That education's paying off for me. All right. At this point, we're going to ask Commissioner Torbett to lead us in an invocation. And following that invocation, if you all will please stand, she will also lead us in the pledge to the flag. Stacy.
Dear Heavenly Father, I thank you so much for the opportunity to be here. Thank you for the safe travels and good health of all that you give us with today in words and actions.
And all right, please stand. Thank you, Stacy. Next up is to approve today's agenda. You all have been sent that. Any additions, deletions, items to discuss?
Second.
All right, Mr. Ferris moves that we adopt today's agenda. Mr. Bagley seconds that motion. It sounded like Joe from a distance. Okay. Without objection, Mr. Bagley seconded that motion. Any discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. Next up is to approve the minutes from our November meeting. Mr. Diaz makes a motion to approve those minutes. Mr. Gwynn seconds the motion. Discussion, any additions or corrections? If not, let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no, and that motion passes unanimously. All right, we're up next to informal appearances. Ms. Matlock, so do we have 3 or 4?
We have 3.
3, okay, and we got them identified as A, B, and C, and then letters after them, like OL. What do those letters stand for?
Those are initials?
Of the candidate?
Yes.
Okay.
Okay.
So are we certain all 6 people are here at this point, or we need to check?
I'm not certain, so I'll go ahead and call their names
Okay.
to see if they're here. Olivia Langford.
I'm here.
Okay. And Principal Broker Pablo Priera.
He should be here. He was dropping his daughter off at school. I'm expecting him any second.
Okay. He might come back to you.
Yes.
Until he gets
Okay.
here. Okay.
That's fine. Thank you.
The second candidate is Mr. Jeremy Deal.
Yes, I'm here.
And Principal Broker Jerry Baggett.
I'm here.
Okay. And the last candidate we have is Joshua Van Zyl. Sorry if I messed that up. Okay. And Principal Broker Mark Williams.
Yes, I'm here.
Okay. We have everyone here.
Let's go to candidate B and let's
So,
say Johnny Dell.
Jeremy Deal.
Jeremy, I can't hear.
Deal. So you have Mr. Jeremy Deal before you. Principal broker is Mr. Jerry Baggett. Mr. Deal has not taken the Tennessee Affiliate Broker exam. And the disciplinary notation is going to be theft of property. And Mr. Deal's statement and letters of recommendation can be found in your packet.
Thank you, Anna. To all the candidates and to their brokers, the procedure that we will follow is in each, at the introduction of each candidate, our lawyer and head meeting guru today will give us a little bit of background. And after we get that background, we can, and probably already have reviewed paperwork that's been sent or provided to each of us about your particular case. But what we'd like for the candidate to do is, in their own words and at their own pace and with as much information as they do or don't want to give us, tell us the circumstances of what got you in this predicament, if it is a predicament, and maybe it's not, what you've been doing recently, maybe why you want to be in real estate, anything you think might be helpful for us to better understand your set of circumstances. Following that presentation, commissioners have the right to ask you any questions they would like to. And once that portion is over, the principal broker or the proposed principal broker gets the floor and can tell us why he or she thinks that you as a candidate would be a good fit with his or her brokerage. And once again, we can ask that broker questions as well. But eventually, and it doesn't necessarily take as long as I'm trying to describe it, we'll get around to a motion to either allow you to move forward to get your real estate license or suggest now's not the right time to get it, and we'll take a vote. We've got 7 commissioners here today, so it's going to take 4 positive votes or 4 votes for any motion to pass. All right, any questions?
No, sir.
All right. So we're going with candidate B. Is it?
Would you like me to start?
I would. Tell me your name again.
My name is Jeremy Deal. A little background with the real estate. My mom.
Jeremy, move to the microphone just a little bit.
Can you hear me better?
That's better. Thank you.
Yes, sir. A little background with the real estate, why I'm interested. My mom sold real estate out in Tipton County for about 15, 20 years. I did some work with her. It's something I've always looked into maybe doing for a career. A lot of fear kept me away from that. My situation as far as a theft under $1,000, I recently went through a pretty nasty divorce. There was a girlfriend involved, and that's where the kayak is what supposedly I had stole. We actually had an agreement to purchase it. I ended up going to jail for about 2 months and then going to rehab. Since then, I pretty much have turned my life around with the stress of the girlfriend and the nasty divorce. I've totally made a 180. I found a closer relationship to God. I've ended up getting a full-time job working in a warehouse. I've got a job offer now with managing some kitchens around here. I've been seeing a therapist since I've been in rehab. It's a different life for me now, and for a mistake like that, or really a misunderstanding, for me to be held back from, moving forward with my life and in my career would be really disappointing. I just hope that the commission can understand that people make mistakes, and we should all have a chance to redeem ourselves, and I feel like this is one of them ways.
right, Jeremy, thanks. Commissioners, any particular questions for the applicant? DJ?
Hi, DJ Ferris here. Thanks for being with us. How long have you been in rehab?
I was in rehab for 3 months. I've been out since June.
June of 2021?
Yes, sir.
And then you've been in rehab since late 2021?
No, sir. I haven't been back since I entered in, I believe it was February and got out in June. Or it was actually March 4th. I went in and got out in June in Murfreesboro at a place called Tulip Hill.
Okay. And are you seeing a counselor or somebody currently? Is that what I understand?
I was up until about 3 weeks ago. My insurance has changed since the divorce, and I haven't seen him in about 3 weeks.
Okay. Thank you. What led you to this particular real estate firm and this particular broker? How did that relationship begin, and what led you there?
I had talked to a few friends of the family, really, through my mom, and then one lady that I have done work for in the past, Miss Teresa Cook, and she kind of led me to Mr. Amo.
Okay, thank you.
Mr. Gwynn?
Yes, Mr. Dill, I want to understand a little bit better about the felony. What does the rehab have to do with the felony? Was your ex-wife, you went over to her house and what she claimed you stole a kayak, and instead of...
No, sir. I'm sorry. It was actually, I had a girlfriend while I was married. The relationship was toxic for years, and I ventured out, which, now I know was a mistake, and I should have, handled it in a different fashion. But the girlfriend, we had decided, actually me and the wife had decided to buy the kayak from the girlfriend. She was having some issues, some family issues, and needed some money. And the time I went and got the kayak, I broke it off with the girlfriend, was going to try to reconcile with the wife. I believe she got upset, and there were some issues with the wife that led me to jail. And that's where I was in jail when I actually found out that she was pressing charges with the theft with the kayak. I went up there to pick. I'm sorry, go ahead.
What were you in jail for as it relates to the kayak, before the kayak incident?
It was misuse of 911. There was some drugs involved. And then with the stress, I was also running my own business at the time. I ended up using substances to work harder and longer, and with the bad toxic relationship. My mom was also had COVID, was in ICU. A lot of stress issues is a lot of it. But yeah, the 911 call, misuse of 911, and a false police report.
False police report?
Yes, sir. That was also one of the charges. And it was all, those two involved the wife. The only thing that involved the girlfriend was the theft under $1,000, which was the misuse of 911 was actually the only felony that I was facing, which was reduced to a misdemeanor.
So was there multiple 911 issues, or just one event?
Just the one event.
Thank you.
Commissioners? Okay, thank you, Jeremy. Jerry Baggett, right, Jerry?
Yes, I'm here.
All right, so you probably know this fellow better than we do. Why are you interested in him being affiliated with your company?
he came in back several months ago and introduced himself to me. I did not know him. I knew some of his family, and I advised him, with this that he would wind up having to come to this hearing and everything, and he was still interested. I spoke with some people in the community who knew him, and they said that, of course he had that, that situation with the wife and girlfriend, but other than that, that he was a good guy and pretty well known around here. And that's one reason why I willing to stand up for him and take a stand for him, is because the way they all talked, that, that situation was not him at the time. That was normally not him, and him being well known, actually, I think he can do good in this business, and he seems to really want to do it.
Commissioners, questions for the broker? Mr. Diaz.
One of the questions we like to ask the brokers is, have you heard anything today that you haven't heard before?
No, he told me all of this up front. I'd
like to go back to Jeremy if I could.
Sure.
Jeremy, I'm just curious about this order to stay away from Ms. Allman.
Yes.
Is that order still in place?
As far as I know, it is. Yes, sir.
Okay, and counsel, Anna, does Ms. Allman have to petition the court to remove the restraining order? Would that have to originate with her?
I don't think it's actually a restraining order. I think it's just a no contact. I could be wrong about that, but no contact with her is something I think was best from the get-go, even without that. There was already a no contact with her. I mean, I come to realization pretty quick of how my actions had impacted not only me but my family and her. It was something that I knew that I didn't need any contact with her in the first place. So
thank you, Mr. Deal. Anna, can you answer that, or how does that work, I guess, is what I'm asking.
I don't know the answer to that. It's been a while since criminal law. So I'm going to have to defer to Mr. Deal. Unfortunately, I don't know the answer, but I guess my question would be, what is the concern for asking the question?
Well, it's just for me, as a real estate agent, in the normal conduct of business, you meet a lot of people, you end up around a lot of people, and I could see a circumstance, just one day, they happen to be in the same space at the same time.
Right.
And, that could trigger some kind of event, I don't know, legal or otherwise.
The court order is still in place. Mr. Deal says so. Unfortunately, I don't have any additional information to provide for you.
Sorry to put you on the spot like that.
That's
I'm sorry.
okay.
Hey, Commissioners, other questions? Steve?
Mr. Dill, are you still on probation?
yes, sir. That is the reason of the board meeting, or my part of it.
So you're on probation for at least two things, the way I'm
Yes,
reading
sir.
it, correct?
Yes, sir.
Okay, thank you.
And when does that probation?
23.
Yes, sir.
Oh, to follow up on that, it looks like there were 3 convictions. The second was for filing a false report, and the sentence, according to the application, was to complete long-term inpatient rehab.
Yes, sir.
Are you still in rehab, whatever that means at this point?
No, sir. That was the 3-month rehab that I stayed in Murfreesboro to appeals. It was that's what they considered the long term, was the 3 months.
That was for drug abuse?
I believe it was for all of them. The stress of of dealing with the problems and the issues I had, not only with the substance, but also with the relationship with the wife, which was a very toxic relationship on both parts. So I don't like to look at it as just for the substance abuse.
Question?
Yes, Steve.
So, Anna, the way I'm reading this, a person wanting a real estate license has to come before us after 2 years have elapsed from probation. And the way I'm looking at it, probation ends 3/2/23, which would mean 25. So am I reading this wrong, or what's going on here?
You're not reading it wrong. Previously, we had rules to amend that particular section because of the Fresh Start Act. The rules in particular were more so targeted towards number 4 in the 1260.01-.01. But when we were reviewing the rules at the time, the Attorney General's office, we asked them kind of what their thought was about the 2-year bar for examination. And we didn't kind of get a clear answer on that. And until we get a clear answer on that, we are bringing all of the individuals that would fall into that category before the commission.
So I can understand maybe coming after, the day after probation ends. Okay, so you're still within, if it's a gray area, okay, but it doesn't make, to me, this kind of flies in the face of what it says if you're coming before us while you're on probation, because it says after probation, at least the way, I just read it again. So I'm just kind of confused a little bit on why this candidate's even here.
So I would just say they're here because of what I stated before, but just to kind of give you some context of what we're looking at. So as long as I've been here, the 2-year bar from even application has kind of been held in abeyance. I know that one of the goals of certainly, I can't speak for the whole department, but I know one of the goals is to allow individuals the opportunity to go back to work and have a career. And that particular rule sets a very firm end. So, for example, Mr. Deal, his probation might end in 2023, but we have individuals whose probation might last 5 years or 10 years. And during that time period, that individual wouldn't be allowed to necessarily have a career in this industry if they so choose. And so that is kind of what it is looking for. I think that rule is very hard and fast rule. I don't have anything kind of analogous to that part in any of my other programs. So while it's still under consideration, and I'm more than happy to have that discussion again with the commission if we want to put that again on an agenda to discuss, that is the guidance that I'm providing. If you believe that because the time period has not been particularly long, that is certainly an idea that you can look at when making your decision. So that is, I guess, another kind of factor. Did that answer your question?
Yeah, let me ask your opinion then. Mm-hmm. Do you think it's riskier for us to grant this to a person that's on probation versus a person not on probation?
I don't think necessarily it is riskier. I think the point of that that of these informal appearances is that a candidate is appearing before you with their principal broker, and at that time the principal broker would be the individual that is going to essentially assume their responsibility. I think if an individual is going to commit crime, I don't think probation is going to be a deterrent necessarily. So I don't really see kind of waiting until after probation and in probation, if that makes sense.
Okay.
And if there is an issue at that comes before the commission because of an infraction such as a criminal conviction, then that is something we can bring. We have remedies for that situation on the back end.
So a judge put that probation on this person for a reason, and the reasons are spelled out in our laws, correct?
The reasons for that particular judge, I don't know.
Okay.
I think it's very case dependent and very fact dependent upon what is going on. So we just have the judgment from the judge. I don't have an idea what they're thinking about. Sometimes there are mandatory waiting periods, but I don't know about specifically for theft. But that comes into more of a deliberate process for an individual when it comes to making their decision of how they're going to navigate the legal field, the justice system. I understand, I'm getting what you're saying, and your hesitancy is valid. And if that is a reason that you're uncomfortable, I definitely think that it would be fine if that was part of your decision. But it may, I do think that it is worth to bring these individuals before the commission to at least hear the questions and what they have to say and see how that goes.
So if the person's on probation, there are certain things that this person has to do. We haven't read the probation order, but there's check-ins and all this kind of thing. So if we grant this and then he, while on probation, doesn't do what he's supposed to do, then we're going to look pretty dumb, I would think. Because I don't want to be in a position to have to be in a backstop to some probation officer. I don't think. You see what I'm saying?
Right. I don't think that necessarily would look poorly on the commission. Like, for example, we have individuals that apply to be a licensee to be for consideration that do have pending matters. So until an individual has a conviction or there's a guilty plea or one of those matters, we can't bar them from applying for that purpose. Also, if an individual was to violate probation, very, again, dependent on the crime and dependent on the decision for that court district, there are remedies for that individual, such as their release date. They could go back into confinement or be fined, or their probation is extended. So the individual, if they do that, is going to have some kind of repercussion on both sides. So if it's on the side of their more so legal side, then that is something that they would need to consider. But also we have, the statute that says if there's a guilty plea or conviction about anything related to the certain enumerated crimes, you have 60 days to notify us, or your license is automatically revoked.
So if you have a felony while you have a license, that we've had this issue, then when your license is coming up for renewal, you have a checkbox that says, have you been convicted of a felony or blah, blah, blah. But it doesn't say anything about not doing what you're supposed to do under probation, correct?
There's not that
It's a-
checkbox.
Okay,
no.
all right.
Mr. Diaz.
All right, sorry.
I just want to go back to Mr. Deal. I mean, I guess the topic of your probation is kind of dominated the last few minutes. So why don't you tell us, what are the conditions of your probation?
As far as I'm concerned, through my lawyer, that it's unsupervised. That's what I know through my lawyer. I've been, pretty much doing what I'm supposed to do since I've been out of rehab. I contacted him like I was supposed to, and that's it. I've heard nothing from the court systems or anything like that since I've been released from rehab. So as far as my concern, it's unsupervised.
Joe?
So you got out of rehab when? June?
Yes, sir, June.
And what have you been doing since June?
At the time when I entered jail in rehab, I had my own swimming pool business. So when I got out of rehab, I went back to that, and I had certain customers that had stayed with me. That lasted me until October. At that time, I went to real estate school, and right after that, I started a full-time job working in the warehouse where I have learned how to receive the trucks in, unload them, and then actually receive the product in, and then to use a reach truck or a forklift to put the product away. At this time, I'm in negotiations with the owner of the Fast Times out here in West Tennessee. They own 7 convenience stores, and I'm fixing to start taking care of their kitchens, kind of getting everything in shape for that. I pretty much have stayed busy and tried to keep my life moving forward in a positive direction, and this was something that I'm really looking forward to maybe doing. I mean, even if you don't grant me the license, or if I pass my test and I get a license, it will be something that I'll be looking forward to doing after probation. It's been keeping myself busy and getting a better relationship with God, really, or my higher power. So
Sounds like you're doing good, keeping busy. But it also, the real estate, it sounds like, is going to be a side business. I mean, you're working toward that warehouse job and the job redoing the kitchens and the convenience places, and so the real estate, you're not dependent on it for your sole livelihood here in the next few months. Is correct?
No, sir, not at all. I mean, when I actually started school, it was just the question of was I convicted of a felony, which I was not. So that's why I entered school, and then on the exit to get to take the test, the questionnaire, I told I had to fill out another piece of paper. So that's where it came in that that since I was on probation that I may not get a license. So it was still me wanting to move forward with the real estate, but I know that nothing's ever written in stone. So that's why I had to keep moving forward and to have a livelihood.
Other questions? So let me just say a couple things. Steve, I think indeed we are working in a gray area when it comes to this probation issue. However, I do think that the intent of the legislature has been to try to make it easy for people to get a second chance. So I generally work under that premise, but by working under that premise, it puts a whole lot of responsibility on the proposed principal broker. And so my decision, as much as the character of the applicant is the principal broker and his commitment to supervise and make sure this guy stays on the straight and narrow. Jerry, can you speak to that just for a minute before we go on?
Yes, I don't mind supervising. It's like I told him, I said, if you are granted a license, I'm sure you're going to be on probation with them at least until your probation with the state runs out, with this incident. And I'm willing to take that on.
But what type of training?
What type of training?
Just an echo.
Oh.
Sorry?
What about training, number of agents in your office? What can you tell us about your firm?
Currently I have 14 agents. We, do training weekly up here. And of course I do one-on-ones with my agents at any time that they feel like they need to. And of course with the new agents, yes, I do a lot more training with them. I'm strict about my paperwork. You do not get paid until all paperwork is done and turned in correctly. So, I feel like I'm pretty hard on my agents as for that. But, I also don't mind working extra hours to help anybody.
All right, thank you.
Thank you.
Commissioners.
Mr. Deal, this is Mr. Ferris again. Are you sober now?
Yes, sir, I am. I just reached a year, the 27th of December.
Congratulations.
Thank you.
F.
Motion to approve this candidate.
Got a motion by Mr. Diaz, second by Ms. Torbett, that Jeremy be allowed to get his real estate license. So we're going to vote on that in a moment. We need 4 votes, yes, for that motion to pass. Any discussion before we vote? All right, let's vote. I'm going to not ask for a roll call unless we need one. Those in favor of the motion vote aye.
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 Those opposed, no. And the motion passes on a 6-aye, 1 no vote. Mr. Wynn votes no. Congratulations, Jeremy.
Thank you.
You've put your broker on the hot spot, man. Make him proud.
Yes, I did, and that's even more motivation to keep my head straight and keep moving in the right direction. And just want to thank y'all for y'all's time.
Right, good luck to you. You're welcome to stay and watch the rest of the meeting if you'd like, or you can go to work, whichever you prefer. All right, let's go to, let's just double check with Olivia just for a second to see if her broker's made it here.
Miss Langford?
Yes, he's here.
Okay.
Oh, without objection, we'll go to back to candidate A, Miss Olivia Langford.
Yes.
Okay.
And before you is Miss Olivia Langford. Her principal broker is Pablo Pereira. I'm sorry. The criminal disciplinary sanction in question is a felony DUI reckless. The victim is permanently impaired. The statement and letters of recommendation can be found in your packet and on the iPads. Also, Ms. Langford has not taken the Tennessee Real Estate Affiliate Broker exam.
And Miss Langford's broker's name?
Pablo, and the last name is Pereira.
All right, Miss Olivia, you saw how the first one went, so we're going to turn the floor over to you. You make your statement, tell us as much detail as you think is important for us to know, and you've got the floor. Go.
Okay. Well, I just want to thank you all for having me here today. This began in June of 2014. I had just completed my second year of law school at the College of William and Mary in Williamsburg, Virginia. I was working at the U.S. Attorney's Office for the Eastern District of Virginia at the time. I was working in Norfolk that day. I had friends in the area, and we were going to go to a concert. I was supposed to ride with them, but they had not gotten off work yet. So I drove myself and had intended to ride back with them. However, I consumed alcohol that night. I've actually blacked out and do not remember the events of that evening, but what transpired was instead of leaving with my friends, I attempted to drive my own car, and I struck a pedestrian as I was leaving the concert, and she suffered an injury. She broke her leg and did have to have surgery on her leg. Thankfully, she made a full recovery. I know it could have gone the other way. It could have been much worse. After that happened, it took about a year of going to court, but I did get sentenced to 5 years. Not 5 years, 5 months. It was 5 years with all but 5 months suspended. So I served about 10 days in jail, and then the rest of the 5 months I served on house arrest. During the time leading up to that, the year that I had of going to court, I worked in a restaurant, and I did attend substance abuse counseling at the New Leaf Clinic, which is part of the College of William and Mary, and volunteered at the Legal Aid Justice Center in Richmond, Virginia. After I finished my house arrest, I did move back to Memphis, Tennessee, to be near my family, to have my support system. When I was at College of William and Mary, I did not have a support system there, and I believe that did contribute to the events of that terrible night. Like I said, I moved back. I had my support system. I was hired to work at FedEx Express. I worked in their recruitment center for 2 years. After that, I went to work at Hodges Law Firm in Germantown, Tennessee. It's a real estate law firm. I worked as a real estate closer for 2 years there, and that is where I developed an interest in real estate. I learned a lot from those attorneys. I became interested in real estate investing. Don't hold it against me, but I've done some wholesaling for the last few years. That's actually why I left Hodges Law Firm on good terms. I was building my wholesaling business. I've begun house flipping as well. I met Mr. Pereira through Memphis Investors Group. I've been an active member for the past 3 years, and he asked me if I would be interested in joining his brokerage. It's something I had wanted to do, but I did know that there would be a process involved in doing that. Other things that I have done, I have been in counseling for the past 2 years, and I also have refrained from drinking for over 2 years, since September of 2019.
Thank you. Commissioners, questions? All right. Mr. Pereira, you know you're next. Tell us why you're interested in Olivia joining your firm.
I think she may have mentioned the hardest job description in the world. I think she forgot to mention that she's a wonderful mother to a wonderful child.
Oh, that's true.
I go to work. I tell people I go to work so I can rest. We got 5 kids at home. So, my experience with Olivia has been nothing but very positive. I was trying to do the math. This happened almost 8 years ago for her. And I think she told you how she has paid that price, which was an awful night that has no memory of. But professionally speaking, Olivia is terrific, involved in the real estate community. And so I have, over the years, talked to her about her considering getting a real estate license and really helping people. And obviously, we would love to have her on our team. She's happily married, a wonderful mom. This happened many years ago, but we will be greatly honored to have her and her business acumen as part of our team. So we will be gladly extend any support that we can to help her get a real estate license.
All right, Commissioners, questions for Mr. Pereira. Mr. Diaz is going to recuse himself, and we'll talk about that in a little bit.
I'd just like to make a statement. the reason why I'm going to
No,
recuse.
don't make that statement yet. It might influence the
Okay,
vote.
go ahead.
Okay. We'll get to you.
Okay.
Are there questions for either the applicant or the broker? If not, is there a motion?
I got a question.
Okay.
Can you, thanks for being here. Can you describe the business you've been part of, wholesaling properties, as you mentioned?
Right. So with wholesaling, again, I'm not licensed, as you know. So wholesaling is assigning contracts, making an offer on a property to purchase as the buyer, and then assigning my equitable interest in the contract to another buyer for an assignment fee.
Else, DJ?
No further questions?
Steve?
Yes, just a quick question. How many transactions, say, in the last 12 months do you think you've been involved in?
In the past 12 months, I've been involved in approximately 5. I did have a baby, as he mentioned, she's 1 year old, so I had kind of slowed down in the past year to be at home with her.
Thank you.
Okay, other questions? Joe?
Are you planning on trying to continue to wholesale if you get a real estate license?
Yes, most likely, yes, as long as it remains legal to do so, and I definitely intend to follow the rules.
How do you find the properties to wholesale? How are you soliciting those?
I find them just through various marketing methods. Right now, I'm doing direct mailers to like postcards to motivated sellers.
There could be a little bit of a paradigm shift when you send those postcards. Now you want to list that property instead of purchase it individually.
It would depend on the seller, if they wanted to list with a realtor or if they were interested in a cash offer, quick closing sort of situation.
And your company's policy, right? I mean, that would have to be
Right.
a factor as well. All right, any other questions? DJ?
Just a remark that if this candidate gets approved, if they do continue to do said mailers, then they would be expected to disclose their.
Absolutely.
And it just needs to be recognized that that would need to be disclosed on any mailing, marketing, advertising that you are now an affiliate with the license and.
Okay.
Absolutely.
All right, with that said, is there a motion with full understanding? DJ, Jeff is recusing himself from this vote. Steve?
Motion to approve.
Is there a second?
Second.
Second by Ms. Torbett. Discussion? If you're in favor of that motion, please vote aye.
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 Those opposed vote no, and the motion passes, and you're on your way, Ms. Langford. Now that you're out of the way, the reason I wouldn't let Jeff speak is because Pablo is Jeff's broker as well, and I was afraid that might hurt your chances if it was disclosed before the vote came out. But he speaks highly of you, Pablo, to me privately.
We give it enough tacos on Tuesday to do that. But no, we think hell of you guys. I want to say thank you to all the board for giving Olivia a chance. I know the topic of we feel as a brokerage very similar in line with what the Trade Commission feels regarding wholesaling. But I think that what you're seeing here is a shift from people trying to do business incorrectly, perhaps, or getting in the weeds, shall we say, with this pseudo industry of wholesaling, and rather get the real estate license and do it right and do it ethically and helping people the best way. So I think that I appreciate you guys passing for Olivia. We'd be really excited for her to join us, obviously. But I think that shows you the shift that we can, as real estate practitioners, tell people that they can join and do so and help people and have a great career doing that.
I think counsel with the Department of Commerce and Insurance has a recent court case that talks about that equitable interest and the fact that you need to have a license to do what wholesalers have been doing here for years without a license. So I think the shift is in place.
Yep.
Good luck to both of you, and you're welcome to stay as well, or you're welcome to go to work. Jeremy, I
appreciate it so much.
Jeremy's still up there checking in with us. I think he's trying to get closed for the test. I'm not sure what. All right, guys, thank you. Let's go to candidate C.
Thank you, guys.
Thank you.
Candidate C, the individual that you have before you is Mr. Joshua Van Zyl. Principal broker is Mr. Mark Williams. Mr. Van Zyl has taken the Tennessee Real Estate Affiliate Broker exam. The summary of the disciplinary sanctions states unemployment compensation fraud. The statement and letters of recommendation can be found in your packet on the iPad.
Joshua, can you hear us?
Josh, hey, this is Mark Williams, the principal broker for Halo Realty. Joshua had to step off with a call, and he said he could get back on probably in about the next 15 minutes. Do y'all have some other business you could do for about 15 minutes?
We always have additional business we can handle. Well, we're gonna take care of one more piece of business. We're gonna take about a 10-minute break, and then we'll come back and see if you guys are ready to go.
Okay, great.
Okay.
Thank you. Thank you.
Okay, let's move on to a waiver request here. Mr. Harmon's waiver request.
Yes, Mr. Harmon is a waiver of the late penalty. He has not paid the $75 renewal fee, and you have a letter from a doctor on your iPads.
Is this an E&O issue?
It is a license expiration.
When did it expire?
The license expired on 2/16/2021. So it hasn't been a year yet. That would be 2/16/2022.
Stop the clock when they ask for a waiver. Does the staff stop the clock when they ask for a waiver? Or at 2/16/2022, is he going to be out of no chance at all?
2022 would be the 1 year mark, but if there's a reason that you wanted to hold this matter or roll it to the next meeting, I think it would be fine, but also the next meeting I think is also before 2/16/2022.
I'm not so concerned about that, but it seems to me like it ought to be more than $700 or whatever it is he's asking at this point.
It's $900.
$900?
Yes, it's a $900 late fee request, and he has not paid the $75 renewal fee that every licensee pays to renew their license.
So, wants to get his license back. He'll have to pay $75. He should, in a normal set of circumstances, also have to pay a late fee at this point of $900. He doesn't want to pay the late fee, and his reasoning is listed or letters from Vanderbilt Health about some health issues. So, Commission, we've had these before. I've always found Commissioner Torbett to have the softest heart on the Commission for some reason or another. I'm not sure why that is. So, any discussion on this, or is there a motion?
I move to approve the
What's your
help me out,
reputation,
Commissioner
dictate?
Torbett. The 900. I move to approve the licensee request to waive the $900 fee.
All right, Ms. Torbett seconds that motion. So the motion, if passes, would still require this licensee to pay the $75. He just wouldn't, or she, whichever he is, wouldn't have to pay the $900. That's the motion on the floor. That's the intent of the motion. Is there discussion? Steve?
So why does the sheet say 75?
He's still going to owe that. That's a renewal fee.
If you look up in the chart, it is on the 5th row. It'll say the fee request is $900.
Not on the sheet in our book.
Oh, you're not seeing it? Oh, okay. Well, it is $900.
I just want to understand what we're waiving. Are we waiving $975?
Oh, $900.
$900. And he's paying the $75 because of for what reason?
Renew your license and not have a penalty of $75.
He would have paid $75 in a timely when he was supposed to. He's good, but because he hasn't paid it, he's got these fees of $900.
So he won't pay the 75 is a moot number. He won't pay that. It's
if he pays the $900, he's not paying that. He's waiving. We're waiving.
He requested to pay the $900 given his circumstances. Okay.
Is the $900? How long did it take to rack up $900?
Well, the license expires next month. It expired in February of 2021. The 1 year mark is February of 2022. So we're at 11 months right now.
Oh, it's 11. So the number for a year is greater than 900.
It's $1,000.
$1,000. Okay.
Or maybe it's $1,200, but it's bigger. I mean,
you have a chance to pay throughout the 12 months and reduce that number down from 900, right? In other words, if you paid 6 months, it's going to be whatever, 500.
Right.
Okay.
So if the individual pays on time, it's $75. After the period of which the license has expired, you start to accrue late penalties for each month that passes.
How long has he been licensed?
I can give you that answer. He has been licensed since August 24th, 1992.
Okay.
Not a grandfathered licensee.
He is grandfathered.
He is. That's why he wanted.
Again, all that information is not on the medical waiver request on our iPad. Sorry, I'm asking. But
those are good questions.
Yeah.
Ms. Smith, bring that microphone down to you just a little bit.
Do we have a time frame for him to pay, for us to waive this? So if he waits another month or 2 months, and he hadn't paid, then are we waiving 900 of the 1,200 or the 1,000?
We're waiving 900. That's the amount that would be due right now. So if he does not pay timely, then it will continue to accrue.
Oh, that's a really good point. I mean, we can waive $900, but that's just if he stays in the current month of default.
Oh.
If he was to wait until the February date, it would be $1,000 at least.
Behooves the applicant.
So my question would be, when he owes the 1,000, are we subtracting the 900 off the 1,000? Is that what we're doing?
Yes, that's how it would essentially work. Plus the $75 renewal fee.
That's a great point.
That is a good point. Could we go back to him and say it'll waive now if you
we give him I guess, do we want to set a clock and say
set a clock, and if you don't, then it's 500, or give a little bit, but make sure that he feels the pressure to make the records whole with regards to his license here at the commission. Or has that been done before, or that gets muddy in the water?
So, DJ, you made the motion. If you want to amend your motion and say that we'll waive it as long as his fee is paid by the 1st of February or some date certain, I think.
Yeah. I think I'll amend my motion. I move to request the licensee to renew his license by the 1st of February for the full waiver of $900.
Stacey, are you okay with that concept at this point? Okay. So if he doesn't, DJ, what do you think should happen on February 2nd?
Groundhog Day.
Groundhog Day, yeah.
Should happen over and over.
I would think the intent of your motion might be that the waiver of $900 is good through January 31st, 2022. If he hadn't renewed his license by then, the waiver goes away and he owes the full amount. I mean, that's what
I think that's simplest, yes, yeah.
Okay, so it's by the 1st, so essentially it's due the 31st, and he cannot pay on the 1st.
Well, whatever date ends up in the motion, but the concept is, okay, we're giving him a break. He's
Right.
got to take advantage of it, and he's got a short window to do it. And if he
Okay.
doesn't, he's out of luck.
And if he doesn't pay it, then he is communicating that he no longer wishes to hold a license.
And the 31st is on a Monday.
Right. No, I understand that part. I just wanted to make sure if the 1st was an available payment day, or if 31st is the last day for payment.
31st is on a Monday.
I say one word.
Sure.
You know, if he doesn't renew by March 1st, he has to retest. He's back to square one, right? Anna?
Yeah, and he loses grandfather.
So he really only has 45 days to take advantage of everything anyway, or it just starts. It would be null and void at that point, right?
My guess is if he's watching, he'll renew this morning at about 10 o'clock. Okay? And that's what should happen if he gets this break. Yeah.
And
That should be pretty
submit
easy.
any of the additional documents that they have to do, but not CD.
And pay the $900 unless we waive it.
So I'm going to restate the motion. And let's see if, and I'm not trying to make the motion, I'm just trying to restate. The motion on the floor offered by Commissioner Ferris and seconded by Commissioner Torbett, if passed, would give this licensee until January 31st, 2022 to get his license active by paying a $75 fee. And if he does that by January 31st, $900 in late fees are waived. If he passes that threshold, he's back where he is today. Is that okay?
That's affirmative on my end.
One last question,
Yes,
since
Steve.
the form's not filled out. Is this an affiliate broker license or a broker license?
Sure, I'll fill in the information, just so you know. The license expiration date is 2/16/2021. He's been licensed since 8/24/1992. The license type is a real estate broker. He does have current E&O insurance and is grandfathered status. No disciplinary history.
All right, let's vote. You've heard the motion. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. Let's take a 10-minute break roughly and come back at 10 till 10. Or is it 10 till 9? 10 till 10.
Yes, I'm here.
Hey, is Josh with you now?
He is. He's back online.
Okay, we're ready to get started. This is informal appearance number 3. And once again, Anna, I know Josh's first name, but I didn't write down his last name.
It's Joshua Van Zyl.
Yes, that is it. Okay, we've got the screen back on. Hold on one second. Where are my... The candidate before you is Mr. Joshua Van Zyl. His principal broker is Mark Williams. Mr. Van Zyl has taken the Tennessee Real Estate Affiliate Broker exam. The summary of the disciplinary sanctions is going to be an unemployment compensation fraud. Mr. Van Zyl's statement and the letters of recommendation can be found in the packet and on your iPads.
Thank you, Anna. All right, Josh, you've seen this twice. Well, maybe you haven't, but at this point, you get to give us your statement. Tell us what happened, why it happened. you've been doing, what you'd like for us to know about you and your situation. You have the floor.
Sure. So thank you. First of all, thank the commissioners and thank Aaron Smith for the communication back and forth. It's been really key to getting this finally here. So back in 2011, I received unemployment from the state of Alabama. At that time, I'm a single dad, so I had to pay a lot of child support. I also worked a job with Danny Hall cleaning a doctor's office, University Orthopedic Clinic in Tuscaloosa, Alabama, for $25 a night, cash. He would pay me $125 a week cash. He would leave it in an envelope. I did not know the threshold for a 1099, but at the end of 2011, Danny sent me a 1099. Well, at that point, I filed my taxes and I claimed the income. The state of Alabama found out about it during an audit, and in 2013, I was brought up for charges of unemployment compensation fraud, which is a Class C misdemeanor in the state of Alabama. I pled guilty once I found out about the issue. I went to jail for about 8 hours as they processed me. I ended up having to pay back 26 weeks of unemployment for a total of $2,381 to the state of Alabama. I was on probation for 2 years. I successfully completed that probation in July of 2015. I also paid back a $1,000 fine to the state of Alabama. Why real estate? So I have been very intrigued by real estate since I was in college at the University of Alabama. I took a real estate class. I've never really been able to pursue that dream. I've always had a really demanding first career. I still have a very demanding first career. I'm currently the Director of Quality for Beretta USA. Beretta's been here for 5 years in the state of Tennessee. Senator Hagerty did a great job of getting Beretta here. And I'm really thankful for my job with Beretta. That's what took me a little bit longer to get back with you. Mr. Beretta is in our facility today, so I had to present to him earlier. But why real estate, again, is something that's always intrigued me. I moved to the state of Tennessee 5 years ago from Alabama and had a very difficult time of getting acclimated. I think a real estate agent can help those that are moving into our state from other places and also help relocate families in a very difficult market. So I'm very excited about the opportunity to be able to help people. And also this will be as we talked about earlier, this will be a secondary income for me currently. I would love for real estate to be a primary income, and that's my goal for 2023. But I met Paul Goode, who is a Sumner County Commissioner. Paul works for Halo Realty. Paul and I have been great friends for several years now, and Paul kind of is the one that guided me towards Halo. I interviewed or kind of called a couple of other opportunities, a couple other places, but once I met with Paul and once I met with Mark, I knew that this was the right place for me, that Halo would give me the opportunity to grow my knowledge and understanding of real estate, but also help me achieve that dream of helping people relocate and helping families start back over again in a new home. So this is something I'm very excited about. I did not know that prior to completing the real estate exam and all the things that have followed up since then, that this was something that would come up, or I would have already had this meeting before I took the exam. But again, I'm just really excited about it. And I hope that the commission can overlook an issue from 2011.
All right, thanks, Josh. Mark?
Yeah.
Well, let me stop. My fault. Commissioners, any questions for Josh before we go to the broker? Okay, Mark, tell us what you know about the applicant and why you're interested in having him with you.
Yeah, as he had stated, Paul Goode, County Commissioner here in Sumner County, had come to me and said, "Hey, I'm friends with Josh, and he seems like he'd be a good fit for our company, and would you interview him?" I said, "Absolutely." And he came in, we interviewed, and he told me about this situation. And you know, as I listened to it, you know, knowing that I believe, unless somebody corrects me if I'm wrong, but misdemeanors drop off in Tennessee after a period of time, don't they?
We don't give legal advice here at the commission.
Yeah. But that was my understanding. But, just thinking that apparently in Alabama, it stays with you for life, and at least for now. But listening to his story, I mean, I think he'd be a great fit from a real estate agent perspective with him being at Beretta, lots of contacts, a lot of people moving in and out of town, that kind of thing. He said he's already missed many opportunities, actually. And he's going to work hand in hand with Paul until such time as he decides that, he may go full time with real estate. But listening to the incident that happened, it really doesn't bother me at all. I can see where that mistake could have happened, and with anybody, and somebody hired him to do a little job. He's saying that, and Josh, you can correct me, did it for about 6 months. And
That's correct.
Yeah, was being paid cash. Never really thought that was a problem or an issue. He wasn't purposely trying to break the law or anything. And so I just feel like, it's an incident that happened many years ago. Of course, he made it right as soon as he was notified on it. And so I don't think that would play a negative part with him in the real estate business at all.
All right, Commissioners, questions? If not, Mr. Diaz.
Motion to approve this candidate.
Motion by Mr. Diaz, second by Ms. Smith, that Josh's application be allowed to proceed on to the licensing phase. Discussion. If you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Good luck, Josh. Mark, one question for you. Is HALO an acronym for something, or what's the origin of that name?
Yeah, the origin of the name, the owner of the company is Danny Hale, and his last name, H.A., they took the H.A., and then he was in partners with a man years ago, and his name was Lowe. And so they put the H.A. and the L.O. together to create HALO. And so he's just stuck with that business name ever since.
Good answer. I work for a company called Hall Rob. Nobody knows what that stands for except its owner's two kids, Holland and Roberts, first three letters. So I just was curious how it came about. Good deal, Mark. Good luck with Josh. And Josh, good luck with Mark. You guys.
All right. Thank you very much. We appreciate it.
Have a good career.
Great. Thank y'all. All righty.
All right. I'm moving back. Yeah. All right, we're to the education report now. It appeared to be an awfully long report. Ross, was that because you're not planning on being here next month because you've got a grandbaby coming or anything like that?
No, Mr. Chairman, thank you. I could have to leave at any minute if that happened, but I think everybody's we're ready to see that baby get here, but that may be a little later this month. But you're right, it was a larger agenda here for me because of the extra month we had there off. But we put together a fine agenda for you this morning. Mr. Chairman, members of the Commission, I'd like to put this before you today for your approval. And J1 through J46, I have reviewed all of these courses and providers and instructors for your approval here this morning. I that reason.
The education director wants us to approve courses J1 through J46.
So moved.
Motion is made by Mr. Diaz and seconded by Mr. Glenn. I'd like to pull out three courses just for a quick discussion. So I'm going to pull out J12, 26, and 27. Okay? But the motion will be to cover the other 43 courses. I pulled out 12, 26, and 27.
Okay, thank you.
All right, discussion on the motion. The motion is to approve all courses recommended for approval by our education director with 3 exceptions. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes. Ross, can we go to J12 just for a second?
All right, Mr. Chairman.
So the course is a real estate finance and tax course. I don't like the description of it because it says this course offers an invaluable resource for real estate professionals in dealing with advising on financing for real estate transactions. Like a lawyer would advise, Ross, or what does that mean?
Not like a lawyer, but just your basic concerns regarding those things that an agent on his understanding of financing and tax issues. Not specific, that too specific that a lawyer would have to be involved to teach it. Also of note, this is a course from Trees. They had about 20 courses they submitted, and I believe this is already a course that's on the books, but they submitted these for internet purposes. Formally, it was a classroom course, but this is an internet course, and so they had to resubmit these for that purpose.
You know, it's an internet course because of the I in parentheses. Is that what that means?
That is correct.
See, now I'm starting to pick up on how you work.
Yes, sir. That's it.
And it's a 10-hour course, and there's that much material in there.
Yes. I've reviewed that before for other purposes, but it's more of a general understanding. It's not in the nature of having evidence.
I'll take a motion on that in a moment. Just quickly on 26 and 27, just the course title. Like on 26, it says Accelerated Office Broker Course. To me, that sounds like I could take that course and get it done quicker than if I took any other broker course, similar course.
Chairman, review of the course, it's simply the Office Broker Management course, but they titled it, I think, to be a little creative. The provider did. Both these courses are our general 30-hour courses for those pre-licensed or post-licensed for Office Broker. And so it doesn't really change the fact that what it is the course that we know now as the pre-licensed new affiliate course and the post-licensed broker management course. So that's all it is. They just I'm not sure why they I have been in contact with again the provider, and these were some courses also that were on our books, but she had had a misunderstanding about the renewal process, and so she had to resubmit these all as new courses. Again, they had already been on our books last year, but she had to resubmit them to get them in because she missed the expiration date on the renewals. So now provided that the commission approves them, she'll be back on the books with these courses.
One question on those two courses, 26 and 27. The word accelerated in the title, is that the name of the course that we approved?
It is the name that the provider gave the course, but as when I prepare these, sometimes they don't use a uniform, as we know what the 30-hour courses mean and what they're supposed to be, and so the provider doesn't get that, and so they'll use a creative word or two to describe the course, but essentially that's what these courses are, and again, they've been on the books.
A marketing point, I'm thinking I'm going to have to take this. I can find one that says accelerated in the title. It causes me to think that maybe I can get it done quicker than 30 hours.
And I think that is a marketing purpose.
But it's misleading. Not accelerated.
It's still 30 hours, but they just have it in their timed outline gets it done as quick as you can, I guess, but basically for the time that you need to get it and setting it within the 30-hour parameters.
I think they answered my question was who labels these classes? The provider labels the classes, names the classes, is that correct?
Yes, Commissioner. Each provider can name, of course, what they wish, and a lot of times I'll come and discuss this with them and explain that certain courses we understand what they're supposed to be and they have a certain name, but these two I just put it down exactly as I got it so you would see what they said.
I have one more question. One back on number 12. We can go to number 12. Other one, right? Can we make a suggestion based on what Commissioner Grease is saying about advertising? In the language there, it's talking about what the class is, advising on financing for real estate transaction, which I agree with what he's saying. It almost sounds like you're giving some advice outside of our scope or that instructor's scope. So are we allowed to make suggestions on changing that language?
We can do whatever we want to. What would you like to do? We can even call on the course provider to talk to us if we need to. He's close.
Oh, okay.
I'm going to get to Bill in a moment, but if you need to talk to him before I get to him.
I personally would like to see that language changed on number 12. I agree with you. It almost looks like you're giving a professional advice outside of our scope.
Really, I think that's Ross's summary of the course, not necessarily what the provider.
And that was my question. Is that your summary, or did this come from the provider?
Well, each provider has to sum up and give me course contents and something that I can use to present to you all. And I feel like, this sort of encapsulates exactly what the course is doing, although it may, it may beg the question. That's exactly right, and I appreciate you're looking into that. But if it needs, the course itself, I think, meets the muster of the rules and regulations. The description is something that I use a little wordsmith myself to put things, to give it a kind of a generic term, and that's what I attempt to do here. But I base it on what the provider has sent to me, and actually I don't go verbatim, but many times I use just about whatever words they use to succinctly describe what it is.
So back to my other two courses just for a minute. So they're putting the word accelerated in the title of the course. Could they put guaranteed to pass and accelerated course? I mean, I'm trying not to give anybody a competitive edge nor discourage people from being creative, but is there a limit to what the title of a course should be?
In my mind, if it is ingenuous, if they say something that leads to misrepresentation about what they're doing, what the course is about, and all that, then I'm going to let them know that we can't do that. Now, with the word accelerated, I just wanted the commission to see that that's the word that they used. However, there's not really a problem from the content of the course at all, and it's just the way that they used to describe the course.
And I've had a course with that instructor, and they are always by the book, and it's been in-person classroom settings, and so if you feel confident in the content of the course that the 30 hours will be met, then I'm okay with that. But I think it's a really good point about this, because it does make you stop and say, well, maybe I can get this done in 20 hours or whatever. And this is a different topic, but I know I'm taking a continuing ed course online. It's 30 hours credit, but it's a 25-hour minimum online.
Right.
So I'm going to get it done in 25 hours.
Right.
It didn't have anything to say about accelerated.
It was accelerated, right?
It was, yeah.
Or it is.
It is, yeah. It's going to be.
See,
All right, Steve.
I think that's accelerated can mean that they're covering more material in the same period of time.
Yeah.
Not necessarily going to get it done quicker. It's like accelerated math. I mean, it's still math. It's just you're getting done more in a certain period of time.
And if a licensee came to me and said, "Hey, what do you think about this instructor?" I would say that instructor will really come away knowing more, or knowing as much as or more than another instructor might teach you. So,
Instructor and provider is very well respected, and I think I've never had any complaints.
Okay, so DJ, based on your comments, I'm taking it that you want to move to approve courses J12, 26, and 27.
Yes, sir.
I thought that's what you meant. Is there a set? Joe wants to second it. Discussion. If you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no. All courses recommended by the Education Director in January have been approved. Now instructors. Ross, we got
Thank you, Mr. Chairman,
handful
members
of
of the
them.
commission. Moving forward to the instructors, I have 2 instructors for you on your iPads today that I've reviewed for your approval.
Motion to approve these instructors.
Motion by Mr. Diaz, seconded by Ms. Smith, that these instructors be accepted. Is that what we want to approve? We want to approve them for teaching. Is that what we're doing? Approving them? Not accepting them, approving them. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Now back to Bill Wisnett. Bill is sitting here at the red tie. He's the owner, now the sole owner of the Tennessee Real Estate Education Systems, Inc., known as Trees. And Trees is one of the most prolific educators. Is that the right word? Are you prolific? Do you like it? Okay. Bill, tip up the microphone just for a minute. Very often, he's for 47 years, Trees has been.
Chairman Grease, can I ask a quick question?
Sure.
Who made the motion and seconded?
Jeff made the motion, Joan seconded.
Okay, thank you.
You're welcome. Bill?
Yes, sir.
47 years.
47, yes. Ron Osland and I started Trees in a bar one night. And we keep going back there to keep close to our roots. And but we started it back in 1975 when you really didn't have to have, well, you didn't have to have any education in order to take the examination. But you had to have 30 hours after taking the exam. So if you didn't know anything about it, but you're able to pass the test, then you were then told that you needed to learn something about real estate. So we started out purely as a crash course. And then in 1981, the 30-hour pre-license came about. So we quit both of our jobs and started teaching that, and interest rates were at 18% and prime was 21. So many a night we slept in the classroom because we couldn't afford a bedroom. Get up a couple hours early, get the classroom set up, and go for it. So, but just wanted to come over and see y'all in person. I watch your videos every month. At my age, I don't have that much to look forward to. So I was quite crushed when you didn't have the December meeting, but I was able to overcome it. But we have worked very, very closely with the commission over those years, and we went with, I think Sharon Langford was our first educational director, and Kathy Riggs, and now we have the honor of working with Ross White too. So just wanted to thank you all, and if we can do anything, we would be more than happy to be of any assistance to. Had a very favorable relationship with the commission, and I thank you for a little opportunity.
Okay. Well, enough about education. So you live in Gatlinburg, right?
I live in Gatlinburg. Yeah, the hills are alive, especially in Dollywood.
So still plenty of people up there. DJ went with his family after our October meeing.
Right.
And
Yes.
somebody gave him a heads up that he needed to leave early in the morning to get there before the crowd did. Is it still crowded?
Not so much now. It's thinned out since at first of the year.
Not for long, though.
But it's coming. It's coming. It's a crazy market. I know the market around the whole state is you put a house on the market and it'll go very, very quickly. But for some reason, it's just the market's crazier than, say, Knoxville, for example, where you're familiar with. And I was just relating a little story. We lost our house in the fire, but we were building a house during the year before the fire, and there was a house right across our street, and it burned. And they've just built back a spec house, and it's literally 2,100 square feet. It's a complete. It's a box. It's got 4 angles, and that's it. And 2,100 square feet, and it's only listed for $900,000. And the crazy part is, it might sell for 8 something. So, it's an interesting area to live in, I must say, and the locals there know all the back roads, and we have taken and sworn in blood that we would not reveal those back ways so that we can be able to get around the county.
Thanks for sharing that with us.
However, I would be just call me and I can give you code. All right.
Thanks, Bill, for coming down.
Thank you so much.
We
We appreciate you.
I
Yes.
would like to have one of your cards, please.
Yes, I will give everyone a card afterwards, please.
Thank you.
Surely. We're here to meet your every educational need.
Okay. All right, Ross, anything else? Any other surprise guests, Ross, or any?
Surprise guests, and on firm that Bill and Ed Dog Matthews, who is very happy after the ball game the other night, and with their office manager, Lucy Foster, just excellent people to work with. And I submit that to the commission and appreciate Bill being here with us this morning.
Thank you. Thank you. Didn't have to mention Ed Matthews' name, but since you did. All right, we're on to the executive director's report. She is absent, as we've previously mentioned, but any report we need to have is now about to come from our legal department and Anna Matlock.
There is nothing to report for this month. We'll resume next month, but we did want to take a moment to introduce one of our new staff members. This is Dana Lee.
Please come up. We'd like people to come to the front. Did you?
This is Dana Lee. Is working with the Real Estate Commission now.
Hello.
Would you say your name?
I'm sorry?
Tell me your name.
Dana Lee.
Dana Lee, okay. And what are you doing with the real estate department?
Admin assistant.
Work from home, or do you get to come to the office yet?
I'm here at the office until my training is done, and then I'll be working from home.
The trainer is here, and the trainee.
I've been trained by various people.
So
there's not one specific person that I've worked with. I've worked with several.
You think so far?
I love it.
Okay, good. That's what we like to hear. Wait till everybody gets back into this building. Someday it'll happen, I think. Not sure, but anyhow, good luck to you. And if we can help in any way, you want to complain about anybody or anything we need to know that you don't want to tell your supervisor, just come to us.
I appreciate that.
Yeah. On the other hand, don't come to us, okay? Good luck, Dana. Thanks for stopping by. Anything else, Anna?
No, nothing further.
All right, we're going to go on to the legal agenda. Y'all received by email cases 1 through 72.
Motion to approve cases 1 through 72. Accept council's recommendation.
We have a motion by Mr. Diaz, the cases 1 through 72 be approved. Is there a second? Okay, Ms. Torbett seconds it. Now, before we take a vote on that, there are some cases that have been asked to be pulled. I'm going to list those, and maybe other commissioners have cases they haven't notified council about. So if you want to make notes, these are the cases that I have that have been pulled. Number 1, 19. Whoops, let me to do them in order. It's 1, 2, 4, 19, 21, 27, 33, 35, 36, 57, 60, and 72.
Chairman, you should have just voted.
What?
Voted against the motion.
No, these are quick. These will be quick, I promise you.
Actually, the only one I'd add would be 15.
15? Let's add 15 to the group we're pulling out. With those cases exempted from the list of 72, is everybody okay with the motion as it is on the floor now? Everybody got it? Okay. So let's vote. Those in favor of the motion to approve council's recommendation on the balance of the cases, please say aye.
Aye.
Those opposed, no. That motion passes unanimously. All right. Dennis, good to see you. Wasn't picking on you today. I just have a few to go over with you.
No, that's fine.
I know it's fine, but I didn't want to think it was personal. So on number one, let me get these cases up here real quick. Number one, I agree with your recommendation. I just don't agree with the amount.
Okay.
So can you tell? I think 1,000 is more appropriate, but is there a rationale you want to use on this?
I think just given the, and there could also be an argument for increasing it based on the licensee's, I guess, recent entry into the business. So 2017, I think my thought was just, and he was rather open about, what he thinks that he was incorrect about. I think that had some bearing on it. But $1,000, if that's what commission believes it would be more appropriate, I see no objection to that.
I mean, he was open about it, and this is in 2019. He had a somewhat similar finding or
possibly
citation. So, it's my opinion if someone on this commission would like to make a motion to accept council's recommendation, but to adjust the civil penalty to $1,000. Ms. Smith makes that motion. Mr. Diaz seconds the motion. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 2, DJ.
Thank you, Chairman. I read this case and just wanted to make a remark, if anything, to add to what this licensee might know, who's been in the business approximately 6 years here, that all this may well be fine and good, but if they do not put it on the MLS, they need to consult their local MLS rules. And perhaps a letter of, not a letter of warning, I wouldn't say, but if there's another type of letter we could send out that would inform them of the best practice, which is to get this in writing from the owner that they're okay for it not to be on the MLS, because typically a property on the MLS is in the better interest of the client. But in many cases, it's not. In some cases, it's not in the best interest. The client chooses to keep it off the MLS for fear of any number of reasons or concerns. So it sounds like the agent, did what they were supposed to do, but just for their practice going forward, make sure everything is more buttoned down, perhaps. And it may have already been, but any thoughts on that, or do we just need a letter of information? Chairman, what kind of letters?
There's a letter of instruction that could be sent, but I'm not sure that we want to give instructions about the MLS.
No, I wouldn't say so. No.
If there's a code violation.
Yeah, that's a good point.
As an active participant. Yes, I hear your concern.
Okay, yeah. Then I'll move to accept council's recommendation, which is a close.
Is there a second? Thank you, Joan. The motion is to accept council's recommendation on case number 2. Those in favor of the motion vote aye.
Aye.
Those opposed vote no, and that motion passes unanimously. Number 4, DJ.
Be brief on this one. Do we have any information from the complainant's broker? Were they contacted at all, or?
No, I mean, I think you see in my summary that by the end of the complaint, the complainant turns on her broker as well, but there was no, possibly in some of the documentation included with the complaint, there may have been some emails from the complainant's broker, but nothing that really stood out to me as being, all that dispositive.
Yeah, I think I felt that there was just I felt that I guess I felt a little empathy for the complainant that there was 2 real estate professionals there, and she's out, or I think it's a she, but anyway, the complainant is out $4,000. However, with the respondent providing such a high number of pages of emails and information, I thought, well, it looked like they made an effort to be in communication. So I'll just move to accept council's recommendation with the remark that in this month's agenda there were a large amount of out-of-state complainants that
This one was, right?
Right. And, state practitioners need to really dial in their reasonable skill and diligence with the care with out-of-state people, because it adds another layer of complexity to it. So move to accept council's recommendation.
Second by Joe Bagley. The motion on the floor is to accept council's recommendation for case number 4. Mr. Ferris made the motion. Mr. Bagley seconded. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. Next up is number 19. I'm sorry, 15. Thank you, Stacy. Jeff?
Well, that's okay. Actually, I'm rereading the narrative here, and I'm going to go ahead and motion to accept council's recommendation to close.
Second by Mr. Ferris. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 19. Once again, I agree with your conclusion, Dennis. So this is against a real estate firm. And my notes, not always, it's hard to say, it ought to be increased to $1,000, not $500. Do you have any argue with me on
No, other than this one just kind of sticks in my crawl, and that's fine.
Oh, tell me why it does.
This is sort of the third iteration of this. This complaint goes back a year and a half. There are the property, if you remember from when we were in Johnson City, East Tennessee meeting, we discussed the property management that was this is the successor property management here. The predecessor was the one we talked about in November. And so that one, I believe, was a $2,500 civil penalty, which right now that respondent has agreed, at least in principle, to that. That's not part of this legal report. But this is the successor property management. And the manager essentially has admitted that, yes, we signed those checks in that fashion. And probably did it within the first week of taking over. So I think that probably played into my recommendation of $500. But again, no objection to $1,000.
This was a property manager, when she lost the account, wrote the checks to the tenants instead of the successor property management
Correct.
company, which gets a micro to it, irritates the heck out of me. Now, Mike, logistically, so we're going to offer a civil penalty to a firm that no longer exists.
Well, we'll have to probably straighten out that issue. I mean, the way that the manager explained it to me is they have a new license number, and when they applied for a new name, I think they found it easier to just voluntarily surrender their current license and then created this new name with a new license. So they exist just under a different license, under a different name.
I used to deal with a beer board that every time a company got caught selling beer to minors and they got a fine, let's just say their license was suspended, they just let their license go and then open up under another name. And since it was a different entity, they were clean and ready to start all over again. Is that what we're dealing with here, do you think?
No, I think that really that none of it's related. I think that the whole issue of their license and doing a voluntary surrender has nothing to do with any of this. I think it's all just coincidence, really.
All right, other questions? So is there a motion to accept council's recommendation with an increased civil penalty to $1,000? Mr. Diaz makes a motion, Ms. Smith seconds. Discussion? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. And that motion passes unanimously. Number 21, this is, the only thing about this case, and I probably am mistaken on this, but we have an unlicensed assistant who's getting paid a bonus when a lease is executed. And somewhere in the back of my mind, I thought we had some guidance for unlicensed assistants and their principal, their supporting broker that says you can't pay based on production. But for the life of me, I don't know where to find that.
And that was the same sort of thought I had as well, which I didn't find anything. When you think about it initially, yeah, that sounds wrong. But when I looked at the way they described how the bonus was working, it sounded like that whatever lease transaction, regardless of what, let's say it was a $1,500 lease. Well, the bonus wasn't coming out of that. It was just merely coming maybe later, weeks, months later from the managing broker, in this case himself. So it sounds as if that while it is a bonus system, that it's not tied necessarily to the individual transactions. That maybe the optics that may be where the problem is, but as a matter of a per se violation of the rules or statutes, I didn't find anything.
Why did the complainant make the complaint?
It's some kind of, I think, a little bit of an axe to grind. And you see in there, you hear, there's what she described as a bit of a toxic environment, or hostile work environment, which I don't know that there's any difference. I mean, that's a complaint. I think that's why that the complaint is before us, and the extra stuff that's in here about her going outside the purview of what a resident manager would do, or not even a manager, just a worker would do.
Somewhere, I think there's a list that the Real Estate Commission or somebody at some point put together that said what an unlicensed assistant can do and what an unlicensed assistant can't do. Excuse me. For operating system.
Well, the final paragraph, and I'm citing, and this is from 6213-104. A1E, unlicensed resident manager or employee will not negotiate the amounts of security deposits or rentals and shall not negotiate any leases on behalf of the broker. So,
but Anna, just for a second.
Yeah, that's the citation, the one that Dennis just said, 6213-104A1E, that lists the duties of a resident manager.
Oh, I'm good. I'm ready to let this go. I just was relying on faulty memory. Is there a motion to accept council's recommendation for case 21? Mr. Diaz makes a motion. Mr. Bagley seconds that motion. Discussion. Those in favor of the motion vote aye. Aye. Those opposed, no, and that motion passes unanimously. Number 27 is advertising violation. And Dennis has recommended a $500 civil penalty, which I'm fine with, assuming this is his first time.
Appears to be.
But what I want to add or suggest is that I can't see a reason why we don't open a complaint against the principal broker for failure to supervise. I mean, this was a big billboard, right? I mean, it's something that should have gotten approval by a principal broker. So my thought process is approve council's recommendation, and as a separate motion, if necessary, ask staff to open up a complaint against the principal broker. If we can combine that in one motion, I'm fine with it if we need to. Joe makes that motion.
Yeah, I'd like to make a motion that we accept council's recommendation for number 27 and open up a complaint on the principal broker.
Second.
Seconds that motion. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. And that motion passes unanimously. Number 33. Let's see. This is a represent. Can you just give us the slight history on this case?
Sure. This was the one, I believe, that was on the November report where the keys were given to the buyers, probably we think of one day before they should have. Now, the buyer's broker, the respondent in this matter, says that, well, the funds were accounted for at the time the keys were handed off. But, and we don't have the benefit of the contract, but possibly by contract, it was the next day, regardless of when the funds were supposed to, or regardless of when the funds hit. The keys were not supposed to be given the next day. Based on some conversation since that time with the respondent, he seems to not really deny that. He didn't say that he did it. It doesn't admit that he gave the keys a day early, but he believes that this is much out of the seller's broker's disgruntlement with not getting as large a commission as they thought they should have. So I don't see any real basis to change the previous recommendation and the previous decision. But as sometimes when we talk to these folks, we bring these back to you all.
So that's my take on it as well, is the previous decision was a sound decision, unless she wants or he wants us to think maybe it's not enough and we ought to give them a little bit more. But to come back and just say it's an emotional reason why this complaint was filed has nothing to do with the fact that they still let someone in a house before they had the permission to let them in the house. So since this case is open for discussion, that's my discussion on this, is that there's no reason to go back and revisit this. The facts remain the same.
Correct. That's how I view it. And I believe, as I understand it, the respondent gave the buyer the key at the walkthrough, which he didn't deny.
Right.
And the funds had been wired and everything had been signed, sealed, but hadn't been delivered. And the remarks from the commission when this was first brought up was that you need to give the key at the time of closing unless there was some written agreement. And that with this licensee only having been in the business for 4 years, then I think that my opinion still remains that $500 is a good lesson to, if this is going to be your standard of practice, get it in writing and say, hey, I live an hour from the closing table, so when I do the walkthrough, I'm going to give them the key. Is everybody good with that? Okay, well, let's all sign off on that. So I move to approve.
Well, procedurally, we can not take any motion and let the current motion stand, if you'd like. Or you can move to ratify our previous decision, whatever you're more comfortable with. Staff, council, do you have a preference?
Oh, no, I'm sorry.
No, that's okay. If there is no motion, then the chair is going to declare we're through with this discussion and move on to number 35 and 36.
I have a question. On that one, John.
Yes.
So the new recommendation is to close it, but we're not closing it, right?
No, it was to discuss it, I think.
The first recommendation was to close it.
Number 33.
We're going with the $500, right?
Right.
Okay, good.
Did we vote yet?
You said it.
Oh, that's right. We're not voting on it. The chair is out to lunch, apparently. All right, 35 and 36. I want to talk about them both at the same time, if I can get to them. So here we have a principal broker in 35 and a principal broker in 36 who had a complaint related to errors and omissions insurance. Their agents didn't pay their insurance in a timely fashion. And the fine, which is prescribed by law, as I recall, was $1,000 to each one of those. And that's what we approved, or maybe it was automatically approved. As a matter of fact, I'd say staff took care of that, sent the notice out. Now, have they come back to you and said that's not fair, or what?
Exactly, on both of these. Essentially, on 35, the principal broker's position, the respondent's position is that the affiliate just didn't understand what they were told, the misunderstood, and I think I put in there, respondent says the affiliate broker misunderstood the requirements set forth, and what the respondent says were numerous emails from me being the respondent. So, I mean, the whole rule is based on a failure to supervise. So if you think about it, what they're trying to say is that we did attempt to supervise them. So
that's why you decided.
Correct.
Do you have that latitude at all if statute says what the fine has to be?
You. So if I'll bring up the statute real quick. It's 112.
It's not critical to me. Here's what I think: hundreds of principal brokers were fined $1,000 because their agents didn't get insurance.
In its discretion, you have the discretion to change it.
Right. I think it's a slippery slope. It's a precedent that every 2 years, hundreds of principal brokers may show up and say, well, you gave these two guys or ladies or whoever they are a $300 break. We want it too. So I'm talking against the recommendation to reduce to $700. I think it should stay at the $1,000.
On 36.
35 and 36 both.
Look at 36. You already had a question.
Yes.
What is it says the affiliate has also paid a $1,000 civil penalty for the lapse.
Correct. They get a consent order as well, and they've already paid that, which, I mean, in terms of maybe you look at it from equity standpoint or fairness, we're talking about fairness here. If the affiliate's already paid.
So the 1,000 that were asked to reduce to 700 was in the motion or in the penalty phase a couple of months ago. So it was actually 2,000.
No.
So let me clarify really quickly. So what happens in errors and omissions complaints? Most individuals, their E&O expires at the end of the previous year. So that means we have a cycle that begins. From the expiration date until until March 1st in this particular instance, if the affiliate or the principal, if the affiliate renews their errors and omissions insurance, there is not a penalty fee. That's what it's called for the affiliate broker, is a penalty fee. So the affiliate broker actually doesn't get a consent order, they just get the penalty fee in which they have to pay. But at the same time, a consent order is open against the principal broker because that's how it's written out in the rules and statutes. And for the principal broker, it's going to be for failure to supervise. And so the statutes and the rules lay out the different amounts that are supposed to apply dependent on when the affiliate let the individuals know. And for in this particular instance, it would be $1,000. So the affiliate and the principal broker, their decisions are independent. But typically, in those circumstances, we sometimes have issues where we look at a matter and we're like, I don't think that necessarily will fit. If we're not requiring the principal broker to pay that amount for a consent order, then I don't think it would be fair to have the affiliate broker pay that as well. But those matters come to us through, and it's one of the matters that's been delegated. So the only reason that you would see an E&O complaint would be like this one, where they're either contesting it and don't want to pay the civil penalty amount, or they are like counter offering and have another request. And so instead of $1,000, they're asking for $700, and the commission does have in its discretion to lower the amount.
Question. So if you're a principal broker and your affiliate fails to renew and gets the $1,000 fine, is it automatic that the principal broker is going to get a $1,000 fine as well for failure to supervise? Because it seems like it would go without saying that if a person works for me, doesn't do it, I'm at fault as well. So it sounds like it's, by the way it works, it's almost like a $2,000 fine, $1,000 each. Am I wrong on that, or?
So for affiliate brokers, there's a different scale in which the penalty fee is assessed. But the rule states for principal brokers, if the affiliate's license has, if they don't renew or broker released after 121 days, then the amount is automatically $1,000 going forward. So if your decision is to broker release the individual, it's still going to be $1,000 civil penalty.
For the affiliate.
For the principal broker.
Okay.
For failure to supervise. We get these questions a lot, and the reason that my understanding that the rules and statutes are put in place is that there are only a couple of things that are explicitly within the principal broker's duties. Advertising is under principal broker. E&O is also one of those things, and we take several steps to notify both parties. So we send out letters to the affiliate's home address, their firm address, and then we also send out the letter to the principal broker's firm address as well. And those are sent well in advance before the expiration date.
What about email? Send those out as well?
We do send out an email. Also, depending on who you have your insurance with, that insurance carrier will send an email as well. It's typically like the October or November before expiration dates, all the individuals that have policies that it's about to expire.
So this is not so much a recommendation, but a request from the principal brokers to reduce the fine?
Correct. So statute says where we are in time is $1,000, but the commission does have within its discretion to amend that to any amount or no amount.
I am of the persuasion right now to follow the chairman's thinking on this and not reduce the amount.
I follow the chairman's thinking very often, okay? I just don't tell where it's wandered off to while somebody else is talking.
Is that your motion, DJ?
You want to move this?
Should I do these individually or as 35?
Put them in one motion.
I move that for cases 35 and 36, that the civil penalty remain at $1,000 for each case.
Second.
Motion by Mr. Ferris, second by Mr. Diaz, that the requested reduction in commission be denied. the commission and penalty be denied. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no, and that motion passes unanimously. Okay, we have 3 cases left that were assigned to Pam. Pam is not here today, so I hope legal, if they have a question, will say, can we defer it to next month? Okay, but the 2 that I have are basically, just to make a point, number 57. Inside number 57 is a somebody described as the affiliate's assigned firm sponsor. The affiliate's assigned firm sponsor. I don't know what that means.
Okay, so respondents, their agent, it's assigned firm sponsor. So my understanding for this particular firm, they have several principal brokers, and so I think I'm pretty certain that the assigned firm sponsor is internal language for the firm, but it is the principal broker from before, if that makes sense. You could, but that is a summary of what the respondent provided. They are the ones that provided that information in the narrative.
It doesn't affect I think the decision is probably correct. I just, when I hear legal terms, you guys kick around every once in a while. I want to ask about them, and I thought this is a new term I haven't heard. So we'll just leave that alone for a minute. Jeff, number 60. Oh.
Yeah, this is mine.
I'm DJ. I'm sorry. I do have it under you.
Yeah, I'm going to move to accept counselor's well, hold on. I'm not going to move that yet because the reason I'm bringing this up was that I would think a letter of warning or a letter of instruction might be of merit to this respondent to know what they're selling, know what they're buying when they bought the property. They didn't know what they bought. But that's a different matter. But when they listed it incorrectly, and everybody's good on this one. It sounds like everybody's been made whole. There's no complaints. So on one hand, I'm prepared to move forward and accept counselor's recommendation. But on the other hand, a letter of instruction would probably help this respondent who's only been in the business about 6 years, 7 years. I'm open to thoughts on that, but hearing none, I'll move to...
Give them time. They have to ponder this. We don't work quickly.
Normally a fast bunch.
So what we have here is an owner, a licensee owner selling their own property, right?
Right.
So regardless of what they did, they're exempt from the statute. Is that correct? So, we don't have a lot of latitudes. When I looked at it, I thought, well.
No, we don't. No, but I would still hope they learned that they need to tighten up their practice of what they're buying and what they're selling. Maybe this complaint has woken them up enough. So, yeah,
likely
it would have me.
Yeah.
Second.
Okay, why don't you? So let's make the motion that includes 57 and 60 in the same motion. Accept council's recommendation on 57 and 60.
I'll make that motion.
Okay, thank you. And
second.
Seconds the motion. Makes the motion. Seconds the discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. And the motion passes unanimously. And now on number 72, I just, for purposes of pointing something out, this is a case we put off and put it in the litigation monitoring category. And danged if the court case came back with different details than what the complaint had. As I read it, the complaint said neighbors said he knew all about that. In fact, under sworn oath during the court case, they knew nothing about it. So the benefit of just having this in court where people had to swear testimony instead of sending a narrative in is just, I just wanted to point that out. I'm perfect with the case and with the recommendation, but sometimes when we stick things in litigation monitoring, we think it goes into a dark hole. In this particular case, it gave us the answers we need to make the right decision. So with that said, is there a motion to accept council's recommendation on 72? Mr. Diaz makes a motion, Ms. Torbett seconds. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. And that motion passes unanimously. And that ends that particular part of this agenda. Anything else, Dennis? You see any trends coming your way, things that are happening, timeshares lower, higher?
Timeshares appear to be maybe a little bit lower. I think maybe there was only 2 on this one, maybe 3. But timeshares are, when I was with you all in 2016, the general complaint is the same, you know. So no real shift in, you know, facts, or, you know, they're not trending to some different complaint or, you know, basis for complaint. Same thing. We just want out.
But how about buyers who weren't successful in a multi-offer situation filing complaints? Is that happening more and more, or are they?
No, I can't say that I've really seen an uptick in that either. I kind of on what DJ was saying, that there are a lot more out-of-state buyers, and that, like you were saying too, creates another level of diligence. Thank you. That because the person's not, you know, working with the person or working with the broker in person, and much of this is being done by phone and by email, and like with the case that you pulled with where the contractor was, you know, there was an issue about the railing. A lot of that might have been avoided had they been here, but you know, we can't blame them necessarily for being wherever they were at. But yeah, I'm seeing a lot more people buying outside of, you know, the state.
Right, and in that instance, the respondent had a record that they provided of 208 pages of emails. So it should go as a call to all the practitioners statewide that if you are working in this industry, you need to keep accurate records, especially so when your client is an out-of-state resident, because you just have to have everything written and notes and followed up and just protecting your backside.
Did you read all 208 pages? Yes, thank you. I thought you probably did. All right. Okay, Anna, thank you, Dennis. We're back to Ms. Matlock, who wants to talk about the real estate recovery, education and recovery account fund.
Yes. Okay, so there are 2 different parts here. The first part is that I have provided you all a draft copy of the form that I intend to use for these types of requests. It should be on your iPads, and it should say Tennessee Real Estate Education Recovery Account Claim Form, and then the draft watermark. And so my intention of including this form was to get your opinion, to see if there were matters that you don't think if you need when we're looking at a request like this, or matters that have been left out to be considered. So
why don't you give us a likely scenario when people, I mean, this is going to be a buyer typically or a seller? We don't know, but what's likely to happen?
So what happens from a request is you're going to have essentially an individual that has been aggrieved by a real estate licensee. And then that individual will state that they want to make a claim towards the real estate education recovery account. And this form is essentially the information that is outlined in the statute, but also information that I thought would possibly be important for the commission to look at when evaluating these requests. So it's basically asking an individual if they're the complainant or an authorized representative, such as like an attorney filing on their behalf, giving it a summary of the action, what happened, and then outlining the specific violations they believe have been violated of the act, and just asking some more particulars about the different types of questions that come from the statute. So, for example, number 12 says, are you a real estate broker, affiliate broker, or timeshare salesperson in this real estate transaction? The answer should be no for that particular question. That is mentioned in the statute, and so I have converted it into a question for an individual.
So at that point, commission disputes are not included?
No.
Okay. So we don't, this is always going to be a principal, not agent.
And then you'll see the question about being a bonding company. Those are also not permitted, and then what types of damages you're looking for. So that was my intention with the form, is to get some general background information for the commission when these are presented to you. This one today is going to be a little bit different because it's our first one, but moving forward, if we were to receive claims, the individual would need to complete this form and provide all of the documents that are requested in the form, sign the acknowledgments, and then submit this document to us. And you'll see at the bottom it says the form must be entirely completed and submitted to the commission no later than 4:30 p.m. of the 15th of the month preceding. So if you want to be considered for the February meeting, that means that this document would need to be submitted by this 15th. I set that out so to have individuals have enough time to read all of the documents, as those are oftentimes very voluminous. But if you would like more time, that's something that you could do, so that was just my suggestion. And then there's a general attestation that says that the information is true, accurate, and complete to their knowledge. So they would be signing that the information that they have provided is correct.
Oh, just for the record, as long as I've been on the Real Estate Commission, as far as I know, staff has never handled one of these. So we're kind of flying by the seat of our pants somewhat.
So in actually our research, we were able to find there were a couple of claims in 2015 or like 2014. I know there was one for sure in 2015. We have like a internal procedure of how it is to be used, but that's going to be updated since the statute has been updated. So therefore we're looking at it like it's a new process. And so the form, this is what I just kind of came up with off the top of my head. I know that during our discussions, sometimes when we're looking at complaints, there are additional documents that you all want to see, such as like the purchase and sale agreement, that information. So if my goal is just to kind of have your eyes here on the situation, and if there's anything industry specific or something that you want to know just generally about the complaint or the individual that is making the claim, that can be added. So I'll resend a copy of this to you all in hopes that we can discuss any kind of changes at next month's meeting or March's meeting. March.
Steve, I'm going to give one more question. So are we going to actually have a hearing today?
We're going to have, so we do have a claim currently. Mr. Roger Thomas is here, and he's going to provide us a summary of his claim for his client. And so you'll see that I printed off the documents for them. you have the 5-page letter that Mr. All of these are in the paper copies. So you have the 5-page letter from Mr. Thomas that was written with the claim that kind of gives an overview. And then Mr. Thomas also provided us a copy of the documents that are referenced in this letter. So my intention was to have Mr. Thomas explain to us like his idea in the claim, what is happening. You get a preliminary point of view. If you have questions, you can ask questions at that time. And then after the questions, if there's something additional that you would want or request, we can get that information. But also, of course, since these are being given to you day of, we'll send them electronically in advance for the next time that we follow up on the claim.
A couple, 3 questions. Does the person aggrieved have to be a Tennessee resident? It's number 1. Number 2, and number 4. I'm sorry, number 5. The word concise. What do you exactly mean by that? And I think it should state clearly that the person that has aggrieved someone is a licensed Tennessee real estate broker, salesperson, blah, blah, blah. I guess that's probably in the document already, correct?
So the aggrieved person...
Not the aggrieved person, the licensed person that has aggrieved another person is licensed, or when they did the act, they were licensed in the state of Tennessee.
Right. So if you look at like number 10, I'm asking for their name and license number of the licensee involved in the transaction for this claim.
At the time.
At the time of the claim.
Because they could have no license. At the time that the claim form comes, if it happened 2 years ago, or I don't know if there's a time frame that you've got to file within, or if there's a statute of limitations or anything?
So the person that they're filing the claim against is an individual that has held a Tennessee Real Estate Commission license. It is possible that during that time period before it gets to you, that license has been moved into another status. If it's been suspended, revoked, or something of the sort. But during the time of the transaction, we need to know the name and the information of the licensee. I can answer what I meant by concise. I am essentially asking people to write a summary, but not like give 20, 30 pages of what happened. So that's kind of concise, meaning including all of the important information. There's not a particular limit, but ancillary issues that may have come up that have nothing to do with the transaction at hand will hopefully be deterred at that time. And what was the first question?
Person have to be a resident of the state of Tennessee.
Person doesn't have to be a Tennessee resident, but the licensee that has committed some kind of violation of the statute has to hold a Tennessee license.
I just thought of my last question. Since we've had a case on it a little bit, the tax reporting, okay, so a person gets 20 grand or whatever, what is that? Is that income to the person? Is it, you know, you can't just give money to somebody and not have some kind of...
We can't give tax advice.
I'm not saying that. I think it should be clear before, you know, what am I getting?
I can ask people that use calculators on a regular basis that kind of question, so I can check in with fiscal, but We don't have any particular authority that's been written in the statute that talks about how this money is to be taxed. So I would need to follow up on that question for you. I know that the amount does not include interest or costs, but how it's taxed, I do not know.
Well, I didn't expect you to know. I just think it's
Right, no.
it's notice, okay, or some kind of a notice that you're giving money to somebody, and they don't get caught like this guy did today, not thinking they had to report something.
Oh, if money's ever awarded or when it's awarded, it'll come from the Department of Treasury, right?
It'll come from the fund.
I know,
so
but it's administered by.
I think it might be finance and administration. I'm not exactly sure, but one of those money departments. Yes.
People that use calculators.
We don't have a checkbook here at the Real Estate Commission for anything. All right. So is that enough background for us? I think we'll take a quick 5-minute break and then we'll get Mr. Thomas up here. What? Oh, sure. Go ahead.
Just one question. Steve still brought up the issue of statute of limitations. I didn't see any statute of limitations. Is there any time limit to filing a claim?
To the account? No,
Yeah.
I don't see a statute of limitations issue.
Oh, as we take a break, is it your recommendation before Mr. Thomas speaks, we read his letter?
Yes, so I was gonna give you all, before Mr. Thomas was to speak, a second to read the document. So if the chair is okay with it, when you return back to your seat, if you could just give us a heads up or not when you're done with the letter, and we'll proceed that way.
All right, let's take a short break. So, Anna, I'm guessing this is Roger Thomas standing at the podium. And is he just going to lead the discussion? You leading the discussion? Where are we trying to get today is what I'm trying to figure out.
So, Mr. Roger, I think the plan,
Could you pull that microphone down just a little bit?
Right. So I spoke to Mr. Thomas yesterday, and so my intention was to provide you all with the letter that gives you kind of an outline of what has happened. And then Mr. Thomas wanted to come in person and also explain kind of what happened and where they're coming from with the claim. So if you have any questions for him, feel free to ask those. But as I said before, after this meeting, I'll send all of the paper documents to you all electronically to make a final decision at a meeting coming up.
So, Mr. Thomas, I'm not avoiding you. I'm just trying to make sure of the framework. Will we hear the same thing next month? And will Mr. Thomas be back next month to make the case again? Is this just a trial run, or can we make a decision today, or what?
I don't know what is going to happen next month. I think next month is when we would get into the more details of how the claim is going to work out, if funds are going to be dispersed, those type of things. Right now, we're essentially giving you all the facts of the case presented. So it's kind of like the prolonged opening statement and direct examination from you guys to ask him those questions.
I'm okay with that, but at the end of today's meeting, we could have agreed that some money ought to go to his client, or we can say we'll wait until next month to make a decision.
We like to wait until next month for a final decision before it goes, because there are a few other ways we've got to come to an agreement on before then.
So Mr. Thomas is going to make the case for why his client should be awarded or not awarded.
Yes. And,
is that the word, awarded? No,
yeah. I think awarded is fine, or dispersed, funds dispersed that are there. So he's going to make his presentation today, And if you have any questions, ask Mr. Thomas.
On next month's agenda, we'll just, as a group, talk about what we're going to do about his request.
Right. So next month, if we have time to, I'm not exactly sure. I know that we have the panel with Tennessee Realtors. Is it on the same day? So it depends on what we have on the agenda. I know for sure we won't have a hearing because it is just a one-day meeting. So depending on what happens here today, whether we're getting no.
Mr. Thomas, what's your expectation being here today?
I believe we could probably make some findings of fact as to whether how much my client is entitled to recover. There is an issue that we want to make sure everybody is in agreement on, and before we accept a payment, we want to make sure everybody's in agreement. This is just a small portion of our overall case. The matter before the commission today involves simply the actions of a now revoked license holder, Mr. Michael Burchett.
I'm just trying to match everyone's
expectations. But I think we can make a decision today on how much is due my client. Yes, I believe so.
Now, Ms. Matlock is suggesting we don't make a decision until next month. I'm trying to get where our expectations are.
I believe, Your Honor, that's within.
Thank you,
Chairman,
Your Honor. I know, Your Honor, I like that.
Right. Mr. Chairman, that's within your discretion at the end of the day.
Your Honor, I like that's good. So, you would like for us to delay any decisions till next month?
I do know we did have the one issue that we're trying to figure out, which is a specific part of the statute. You all also should have gotten a copy of the statute. It should be on your iPads for you to review. Also, since this is an issue of first impression, we would like to look at the part where we're looking at how many transactions are at play here. So those are the two.
So let's we'll leave it up to commission to see what our expectations are after we hear the facts. This is not an adversarial case, correct? I mean, the state's not arguing with Mr. Thomas. And Mr. Thomas is smart enough not to give us detail after detail after detail. It keeps us here for hours, correct, Mr. Thomas? Okay, just want to make sure of that. All right, with all that background, let's get started. Mr. Thomas, you're a licensed broker. Oh, Jeff, go ahead.
And I do, in these cases, I don't know about in this case in particular, but in future cases, can we expect to hear from an opposing side, or is this?
I don't anticipate to hear from an opposing side in kind of these circumstances. It's really on what the claimant has said. There are certain documents and steps that need to be completed, and then it's up to your decision whether to disperse those funds or not. I don't really see the other side kind of being involved in this kind of transaction. So my vision for how this will go normally, when we figure out all the moving pieces of how to do it, is if you liked the committee portion of the meeting, the committee, which would be 3 people, would meet the day before the meeting to go through the preliminary information and then make a preliminary decision and bring that to the commission the next day. And then the whole commission will make a final decision. So
this first run, we're meeting a body.
Right. We're meeting as a whole body for this one, since none of us in the room right now have done a real estate education recovery account claim.
All right. So, Mr. Thomas, you're a licensed real estate broker as well.
I am, but I'm here today solely in my capacity. Well, other than getting the 8 hours of CE.
That's what I wanted to ask you about.
Yes, I am. I did want to take advantage of getting paid while getting my CE.
I understand.
It's a unique opportunity.
So far, I like your style. Now, if you'll keep it succinct, I'll like you even more.
Absolutely. Let me just give you 30 seconds about my background. for 14 years, I was with the Department of Financial Institutions, first as staff attorney and later as the assistant commissioner over the compliance division. And in that time, I was charged with the responsibility of regulating the mortgage industry in the state of Tennessee. During that time, I also served as the president of the National Association of Consumer Credit Administrators. I was also on the board of the American Association of Residential Mortgage Regulators. I say this all simply to say that I've seen a ton of consumer fraud over my 35-year career as an attorney, and I've never seen a case as egregious as this one. Now, thankfully, this commission has already revoked the license of Mr. Michael Burchett. Mr. Burchett now resides in the Williamson County Jail and will reside there for the next 9 months, pursuant to a criminal plea that was entered on December 3rd. Also pursuant to that plea, he made a restitution payment of $300,000 to my client. That was just a fraction of the money that he stole from her. My client is the exact reason this fund exists. If a client of a licensed broker suffers economic damage through the criminal activity of that broker, that is the purpose of this fund. I'm very thankful for the opportunity to appear before you in basically what is a case of first impression given the recent statutory amendments to the fund. It is our position that pursuant to the statute, we are limited to recovering $15,000 per transaction. We have clearly identified 5 separate transactions, 4 of which we are seeking recovery from. Mr. Burchett had to do this, had to accomplish his theft through a series of different transactions. It started with a property management agreement, and my client never would have purchased the property, the investment property, without a property manager in place. We're not seeking recovery for that transaction, for simply the execution of that, but that was a key function in the remaining transactions. 2 days prior to the scheduled close of the transaction, Mr. Burchett presented a forged amendment to the title companies saying that he would take title in the name of MKB, those were his initials, Holdings, LLC. That was done without the knowledge of my client. But interestingly, he was going to sign on behalf of the LLC as a sole member. Well, it's our position in our civil lawsuit that the title companies, that should have been a red flag for the title companies. That's not a matter before this commission. The matter before this commission is simply the actions of Mr. Burchett. So he was using that forged amendment. He was able to take title in the name of his LLC, MKB Holdings LLC. The day after the closing, shortly after the closing, he sold that house to Open Door, an iBuyer, in an off-market transaction. And then a day or two before that transaction, he presented a lease to my client. This is the second transaction. I'm sorry, the first transaction was the purchase of the property. The second transaction was a lease that he gave to my client showing that the property had been leased. At this point, we've been unable to get any information from Mr. Burchett because he's pled the fifth. And now that he has resolved his criminal case, we will be taking his deposition probably within the next 90 days. But we relied on that lease, and Mr. Burchett actually made payments to my client of $3,000 per month, $2,700, the $3,000 that he was supposed to be collecting on her behalf. We later found out that all he did was give her her own money back. The rental income she was supposed to get as a result of the third transaction, which was the lease, never came. So he ended up selling the house to Open Door. At that point, he got $450,000, or I'm sorry, I think it was $435,000 at the closing of the sale. At that point, he had my client's money. The next day, he wired $100,000 to a casino. We have yet to determine exactly what happened with that money. And he basically, over the course of the next couple of years, kept sending my client $2,700 a month, making her believe that she had a rental property, she had a valid lease agreement, she had a valid property management agreement. After a year, he gave her a second lease, and both of these leases I've given you copies of. That second lease, and then there's an email that I also gave you where he explained, and all these were steps that he took to continue to deceive my client over, through a series of these transactions over multiple years. In December of 2019, he informed my client that he would not be sending her any money in February because he was going to use the money to pay the property taxes. Well, either my client or my client's sister, who lives here in Williamson County and who had actually used Mr. Burchett on a prior transaction with absolutely no trouble, they went to the county trustee's website to see how much the taxes were. At that point, they realized that they did not own the house in question, notwithstanding that he had given them a forged warranty deed, gave them a forged title policy by First American. First American denied the claim based on it being not being a valid policy. So again, the criminal activity that took place over these series of transactions is exactly the purpose of this fund. And we're here today to seek to recover whatever we can from the fund. It's our belief, and we've presented evidence, that there were 4 different transactions, and we are limited to $15,000 per transaction. The statute is very clear. So we're here today asking the commission to approve the payment of $60,000 to my client. Now, as a part of the criminal case, Mr. Burchett paid $300,000. He's going to serve. He was sentenced to 10 years. He has to serve 9 months. At the end of that 9 months, he'll be free. He can work, and he has agreed to pay $19,500 annually for the next 10 years. It is our position that we would repay the fund. The first $60,000 that we collect from Mr. Burchett pursuant to that agreement, we would use to repay the fund. That's the statute contemplates the fund being repaid if we're able to get it. We feel confident because as a part of the plea agreement, if he is late on a single one of those payments, his probation is revoked and he goes back to prison. So he is very motivated to make those payments. And our request would be that we would gladly assign the next 3 payments, 3 and whatever fraction of the 4th payment, to ensure that the fund gets replenished. But like I say, this is a case of first impression, and you couldn't really have an easier case as far as the liability standpoint. We've got a guilty plea. Nobody is contesting what happened here. The only question is, how much is my client entitled to recover, and through what means?
Thank you, Mr. Thomas. Commissioners.
Question: does E&O step in at all?
E&O does not cover the intentional acts. So we may have E&O for the title companies. That's a completely separate matter. That's not a matter that's before here. But for the agent, E&O does not cover intentional wrongdoing.
Question.
Yes, Steve.
How much short is your client right now?
Well, the house, the purchase price of the house was supposed to be $495,000. We are suing for the fair market value of the house today, and that's a little over $700,000. We're also seeking treble damages because we allege violations of the Tennessee Consumer Protection Act, and we're also seeking the ever-important award of attorney's fees under the Consumer Protection Act. But the actual out-of-pocket expense that our client wired to the fund, it was about $495,000. And that's what the DA used for purposes of the criminal restitution.
So she got back $350?
$300.
Of that
Plus to get $19,500 for the next 10 years, which would be the $495,000, which again is just a portion of what we're seeking to recover from all the defendants.
Of the $300,000, did she receive all of that money? One other question. You said there were 4 incidents that you were bringing. I counted 3 purchased And then 2 a lease. And
On
what
page 3 of my letter, I identified the 4 transactions. First being execution of the property management agreement. We're not seeking $15,000 for that. We're just pointing out that is a transaction, and that transaction was necessary in order to have the other transactions take place. The second transaction is identified on page 4 as the initial purchase of 1207 Jepson Court. The third transaction is a preliminary lease in which my client received $2,700 a month. But it turned out that was just the money that she had paid. He never collected rent. The third transaction the fourth transaction is the actual sale of the property to Open Door. That's the transaction where my client probably lost the most money, because at that point she was, as long as he owned it in his LLC, there was, a possibility that, all he had to do to make her whole was deed the house over to her. But once he sold it to Open Door, that was all she wrote for my client. And then the next was another lease. Now, I guess in theory, maybe he did a sell lease back with Open Door and still had the authority to enter into a lease. I'm highly skeptical of that, but we have not been able to depose Mr. Burchett at this point.
Did Open Door get a title policy when they bought it from Burchett? And
They did.
And how did it? It seemed like that would be
the position on that would be that the true title holder was MKB Holdings as a result of the forged amendment. So the deed of trust that was on file in the registrar's office is identical to the one that he gave my client, other than the word grantee. The one that was filed, the certified copy we have from the Register of Deeds office has MKB Holdings as a grantee. The one that Mr. Burchett gave my client lists my client as a grantee. Mr. Burchett was very skilled.
Just out of curiosity, the notary of the...
It's the same notary. It's the exact same document. So we have no reason yet to believe that the notary was involved in any...
So the deed had all the stamps, it had everything it needed on it?
Same ink spots on the same place.
Wow, okay.
Amazingly talented criminal. I want to thank the commission for its action in revoking his license last month, and also thank you for the $200 civil money penalty you imposed. Had you closed more, that would have been less money available to come back to my client as restitution. So if anybody questions why you only impose a $200 civil money penalty, my client would like to thank you for that fact.
All right, Mr. Thomas, stand by for just a second. So your contention is that there are 4 separate claims, each, because of their separate nature, constitute a different claim for...
Different transaction, and the statute is clear that the limit is per transaction, regardless of the number of parcels involved.
Oh, I think I heard Ms. Matlock say that counsel here at the Department of Commerce and Insurance might have a different take on that.
I don't believe that would be the case. I think the question is how, and well, obviously I'll let Ms. Matlock speak, but my understanding, I think the question to be resolved is how to best make sure that the fund gets reimbursed. And the statute kind of addresses that as well. But I think when you read the entire statute as a whole, it is very clear the legislature wants to see victims get reimbursed for the losses of criminal activities of licensed agents. That was why the legislature and the department even came together to relieve some of the onerous provisions that you discussed at your last meeting. So again, we're here in a case of first impression. Now, as to the, I'll let Anna speak to that, but that was my understanding of the issue to be resolved. So, and my suggestion on that is let's go ahead and make a finding today that we're entitled to recover $60,000, but not yet had that paid until all the stakeholders, those being my client, the commission staff, and the Attorney General's office, come to an agreement as to how that gets paid back.
So, one more question. The responsibility to pay it back, it seems to me, should fall on Mr. Burchett, not your
Yes,
client.
I mean, if we get money, if we receive money, I think under statute, we're required to pay it back. But our suggestion, I mean, the only thing that's before here is a claim against Mr. Burchett. We plan to get money from Mr. Burchett. And our reading of the statute says if after a reward of the claim we get money, it has to go to the commission first, and any excess, comes back to us. So we're prepared to assign our rights to those first 3 payments of $19,500 over the next 3 years. So basically all we're doing is we're getting my client $60,000 today as opposed to having to wait 3 years. My client has lost her job due to COVID. This is her entire life savings that has been taken from her. She's halfway around the world. I will tell you, I have felt a tremendous responsibility to my client and make sure to get her hold. And we're very indebted to the District Attorney's Office for their assistance thus far. And now that the criminal case has been resolved, we can move forward quickly on the civil case.
Just one more point. It doesn't seem logical to me that if the fund pays out money because of the actions of a licensee, that the fund should be repaid by the licensee, not the person who is harmed. But that's not how the statute reads?
That's not quite how the statute reads. Paragraph H is what is the point of contention. Not really the point of contention, but that's the paragraph we'd like to work together with all the stakeholders to come out with the most.
All right, Ms. Matlock, any comments at this point?
What the intent today was for you all to get a first impression of what was going on. I know that I had a meeting yesterday with the Deputy General Counsel and Assistant Commissioner, and at the end of that meeting, I spoke with Mr. Thomas because we were having an issue. We thought we were looking at a different portion of the statute, and so what I kind of recommended, or what the agreement was, is to have time to look at that particular issue. What Mr. Thomas is referencing is a previous section H, but if you look on the sheet that I provided, it's the new section G, because a whole section was removed when the statute was updated, so there's relettering type thing. So I know from the legal counsel side, from the Deputy General Counsel and Assistant Commissioner, they would like additional time before making a final decision.
Okay, Commissioner.
And if I may respond to that real quickly. And we're fine. And I guess our request was, I think we have enough to make a decision as to how much my client should be recovered. We simply, if we make that decision today, and then if the commission can authorize an agreement between the stakeholders, the Attorney General's office, the commission staff, and my client, if we can come to an agreement, we'd like for you, if you can, to authorize them to speak for the commission on that limited point.
Frankly,
so
that microphone, Jeff.
I'm sorry. So it's my understanding that she's willing to get $60,000 today, okay, and forego $60,000 in years 4, 5, and 6.
That's what the statute contemplates. The statute says that if they pay, that we assign part of our thing. So we're not crazy about that, but
she won't get any more money until year 7.
No, it's year, yeah.
Months. It's $19,500 per year for 10 years after he gets out of jail. But
he gets out. He's serving 9 months. His next payment is due this December 3rd of 2022. That's the first of 10 payments.
She won't get money for 3 years.
Right.
So we'll get.
We
the
hope.
first-
Well, hopefully, we're going after her.
Yeah.
Yeah, we're going after other people for money.
Yeah, but on this particular thing, we're getting her first 3 payments.
Yes, we're willing. We are willing to do that in exchange for getting her money today. She's been without her entire life savings for over 2 years now. She's lost her job.
Not the 300.
About 3 weeks ago. Yeah, she got that back. That went into the court clerk's office on December the 3rd. I picked that check up on December the 17th, deposited it into her account, and it had a 2-week hold on it then. So she's just recently gotten that.
Mr. Thomas, you understand that we rely heavily on counsel's recommendation here at this commission.
As a former attorney for the Department of Financial Institutions, I advise you to do just that.
Counsel's recommendation to us is to delay while they look into a little bit more of the detail, and your recommendation to us is move as quickly as you can. Let's at least get the number on the table, and that's not handled, not worried anymore, correct?
That is correct. I don't know that counsel would necessarily be opposed to a finding today of that matter. I believe, and Anna, please correct me if I'm wrong, I believe the main issue is dealing with what you say is now paragraph I, which I had referenced previously as paragraph H.
Right, so there is the same issue about paragraph, whatever letter it is, G or H. We are looking at that because not sure how the agreement would work, which we can figure out how to do as well. But I do know there was kind of a question about how many transactions we're looking at. And so the commission is under their purview to consider it for 4 or 5 or whatever they're looking at. We're just wanting to make sure we all come to a consensus with the amount of transactions.
So, it's the question of the category of license. So he was a broker. He had a broker's license, an affiliate broker.
Mm-hmm.
So that license has been suspended. So as an affiliate broker, he signed an agreement as a property manager, but that's not a separate licensed category under the statute. So at all times, he was an affiliate broker. Okay.
If you hold an affiliate or broker license, you can do property management.
It sounds to me like, at least conceptually, this commission has to decide whether, once you employed Mr. Burchett, that's all-encompassing. So there's one violation. Or you can take Mr. Thomas's argument that there are 4, maybe 5 separate acts done by a licensee that individually each qualify for compensation. And we can talk about that concept for a minute if you want. I'm not sure we're going to get to where Mr. Thomas wants to go today, but we might.
Yeah, I see 3. It's the property management agreement. No, I do see 4. The property management agreement, the license, the purchase of Jasper, the sale of Jasper, and then the purchase of the following property. Or
two leases.
2 leases.
Yeah.
So
purchase, sale of Jasper, 2 transactions, 2 separate leases are the other 2, and then you could argue, you could easily make an argument for the 5th being the property management agreement, and we gladly accept payment of $75,000.
At the moment, only talking out loud. Jeff's trying to get it straight in his head, and I am clearly trying to get it straight in my head. Steve, you have a
question. How good do you feel about his ability to pay the $19,500 over 10 years?
You never know what happens in jail. You never know what happens to a person when they are, come out of a different environment. We know he should be very motivated, because if he fails to make a payment by one day, his probation will be revoked and he'll be back in jail. That's about as good of a deal as I think the DA could have crafted for us. We don't know.
This is just a thought. If he were to die during this 10 years, then your client's going to lose again.
That is very true.
And you probably have, I'm no insurance expert, but I think you probably have an insurable interest in him. You might think about getting
That will be a matter of our deposition, and that will be addressed in our deposition with him, which will probably occur within the next 60 days.
So let's, as a commission, let's see if we can get together on one thing here. So Jeff has just counted what he thinks are 4 legitimate different events. Does anybody have a different thought on that?
Well, I can offer a different thought, saying that the property management agreement for whether the 2 leases was one event because he was the property manager under contract.
Here's kind of where I think I'd like to get this thing to go. Is the consensus of commission, at least unofficially, is that there are 4, maybe 5 different transactions, and subject to what council brings back to us next month, that's where we're inclined to go. Just trying to see if Anna knows we're only talking about 1 transaction, and they're concerned that it's only 1 or 2 transactions instead of 4 might be relieved.
No, that makes sense.
So let's, as a commission, somebody want to?
I'll make a motion.
What would that motion be?
That we agree that there are 4 separate transactions, and that Ms. whatever her name is, be awarded $15,000 per transaction.
Second to that.
Do we want to go there yet?
Well, that's a, what if you took the 15,000 off and said that there are 4 transactions we consider claimable?
I mean, that's what we're talking about.
Well,
I mean, it can't be another number.
It's up to 15,000. It could be 10. It could be 5.
It could?
Yeah, it's up to.
If I might.
Yes, Mr. Thomas.
I think clearly the damages on each transaction is in excess of $15,000. We're talking about basically $3,000 a month on the leases. That's clearly over the $15,000. But again, we're perfectly fine in going ahead and making a finding that my claimant is entitled to an award of $60,000 or $75,000 today, but not make that payment until such time as we can address the issues that counsel for the commission has addressed. And I think we could probably come to an agreement prior to the next meeting. And if you wanted to authorize them to enter into agreement, you can do that today, or you can say, bring us your suggestion. We as a commission would like to have the final say so.
I'm not trying to guide this too much, but I really do rely on counsel advisors here, and they're telling us to slow walk this at least for 30 days. So I'm trying to find something that'll give you some reason for being here today that you can tell your client was positive, and at the same time give counsel some reason to look at what we are thinking and see if it fits in what they've finally come up with. That's just me. I don't want to. I like the idea of you.
Perfectly reasonable approach.
Yeah, I like the way you're trying to close this. I think that's great. Get the number on the table. Let's get that one there. But
I like the bump up already.
Jeff.
Ms. Matlock, in the agreement that Mr. Thomas is seeking, how much time do you think between the Attorney General's office and those departments talking to each other, what kind of time are you contemplating that's going to take?
So, I mean, I know on my part, discussing any additional matters can begin soon with the Assistant Commissioner and Deputy General Counsel. The Attorney General office matter, I'm not exactly sure how that will work, because that, I understand what Mr. Thomas is saying, but that agreement is not necessarily in the statute, so it's not really contemplated that the AG's office is included. But if that's something that the commission wants us to look into, based on the facts and circumstances raised by Mr. Thomas, I think that we can certainly do that. I am unable to speak for their time limit, but I can just mention that it's like an expedited matter, so if we could get a preliminary opinion, work with the party for February meeting. I can't make any promises.
And I'm not saying that the Attorney General's office has to be involved. It just, yeah.
No, I understand that.
Yeah, just from my experience decades ago with the state, that's how we would have handled it.
So Anna, question. Can I have a question? So if you look at G, it looks like that it's the subrogation agreement would automatically happen whether or not we have a possibility of getting money back. So it seems like this offer he's kind of making is complicating it a little bit when it already exists. Am I wrong on?
Here's the problem with that. We are seeking treble damages. So we're seeking $2.1 million from them. We cannot assign our rights to a $2 million claim against multiple defendants in exchange for what could be a $15,000 claim from the thing. I think you have to read the entire statute as a whole to get the true legislative intent. And that intent is clear. The legislature wants to see victims of criminal acts by licensed attorneys to be compensated. That's the bottom line. We want to get it concise. That's concise. And that's what we're here today to achieve.
I'd argue that's not the intent if they're making the victim have to pay the money back. They might want to give them a loan.
I like your argument. Yeah. But I'm just saying, if the statute, I can't ignore that statute, but I think you've got to read the statute as a whole. I'm sorry.
My question is, you're presenting 4 violations or 4 incidents. Can that be changed, increased, or is that up to us to look at the whole file?
We've identified 5, and I can see the standing alone, the execution of a property management agreement. I can make an argument either way. I didn't want to appear greedy, but I think it's clear that my client is entitled to 4. I think she's entitled to 5. And if you agree and want to give all 5 claims, you certainly have the right to do that.
We got a motion on the table, right?
No, we haven't got a second yet, but I haven't forgotten the motion yet.
Okay,
I'm just
good.
trying to make sure that you're.
I have one more question.
Please go right ahead.
Okay. Assuming that Mrs. Gow and we make this agreement that she's going to pay the $19,500 that she gets each year back, and something happens to her, would her estate be liable for that debt?
Commissioner, to be perfectly honest, that probably goes a little bit beyond my area of expertise. I've done a lot of mortgage fraud cases and a lot of criminal prosecutions, but I think whatever she's entitled to would, I think we could paper an agreement with the department. I mean, it's clear the legislature wants the fund to be restored. I don't, as you know, we've got $5 million in the fund right now. You've tried to you can't give it away. You lower your fees from $10 down to $1. It keeps growing. That's not the intent here. We're coming to you in a case of first impression asking to give credence to the intent, and that is to compensate our client for a criminal activity. Quite honestly, and it could easily be $75,000.
Steve, you want to restate your motion?
The motion is that Ms. Gow receive payment. I'm not going to say what exactly for 4 separate incidences.
Second to that. Mr. Bagley seconds that. Now, do you want to condition it at all that it's subject to counsel's review or an agreement between the claimant and the state, or some sort of condition on that?
Your Honor, Mr. Chairman, again, I would almost request that we not receive that in light of the potential interpretation of paragraph H, which says if we receive the money, we automatically subrogate our entire claim. I think that's I don't think that's the intent, that we would subrogate the entire claim against all the parties in our lawsuit.
But the way I'm looking at it, if you did that, we'd have to give you the excess back.
may. Unfortunately, the statute says we shall subrogate, and you may give it back to us. We would like a written agreement that you would agree to give it
That
back
we,
to us.
instead of may give back, you want it to say we
Shall.
will give back.
Exactly.
Okay.
And you know, for that matter, the Attorney General's office may look at this case and they may want to join us in pursuing this case. And we're more than happy to have those discussions.
I would think you'd be better off. I mean, I don't know, but having the state of Tennessee on your side is not a bad thing.
We would not.
All right, so we have a motion on the floor that, if passed, will identify 4 separate cases subject to payment, for lack of a better term.
Is the intent of the motion hear about these 4 possible cases? Is that the intent? Or are we deciding today?
No.
So the motion, as I understand it, we'll handle this case today if you pass this motion.
Right, and I'm just going to interject. The agreement that Mr. Thomas is requesting, as I stated before, is not in the statute. So he's asking for an exception on the matter of first impression. The first line says, when the commission has paid from the account any sum to a complainant, the commission shall be subjugated. That's what it says. We're looking to see if the shall is a may, that even if we're coming up with agreement, that would be us looking outside of what the statute says. It may satisfy the intent of the whole section or the whole part, but knowing at this moment you could state possibly that there are 4 transactions, but we still have more matters to discuss at some point. Whether the commission even wants to subjugate all of their rights at that point, which is why my initial request was to have more time to figure it out. Because as Mr. Thomas has said, the way that the statute is written, if it goes exactly like that, that is not going to be something that would be advantageous to his client.
Not at all. And our request is to basically bifurcate this. Go ahead and have a finding today that we're entitled to 4 transactions, but not authorize any payment until we can come to an agreement with the attorney, with the staff, and with the Attorney General's office. It's the subrogation goes into effect when the payment is made. We don't want to make that payment today. We would love a finding today that we're entitled to it, and if we want to continue to pursue it, we would get X number of dollars. We think we can make that today, but I think given the uncertainty, given the lack of time to, being the case of first impression, I think bifurcating this into 2 separate meetings makes perfect sense.
Sounds like the risk is on them, though, because if
Correct.
they take that payment,
That is correct.
they take that payment,
Yes.
and there's no agreement ever made, then if they win $2 million, we get it, and then they take their chances if they get some back.
And that's what
Right.
we came.
Is the risk mainly on them more than us at this
I
point?
mean, the risk is on them when it comes to money. But the risk that I'm looking at is the whole how we're going to handle future matters. So are we going to bifurcate all matters moving forward outside of this? My concern is that if a precedent is being set.
But what I'm saying is, to our actions today, we're not setting a precedent at all. It's the way it's written. He's taking the chance of whether we're going to change that in the future with a new agreement, right?
He's not taking the chance yet.
When he gets the money.
Well, we're subrogating $60,000 to him, and the way it's written, he's got to subrogate $1.9 million to us if he gets it. Under the premise that we're going to give him the difference back of $1.9 million minus $60,000.
Not even a premise, just we might give him.
Well, I mean, he wants it correct. He's assuming that, but he wants it to say it.
So I mean, in that case, I would think additional time to flesh it all out is in the best interests of everybody. And when was the last time this account was paid out of? We don't know.
I don't know when the account has been actually paid. Well, the account gets paid out of every year, but it's in small amounts. But for this particular purpose, I don't think in a long time.
This has not been exercised in some time, is my question.
Correct. It has not been exercised while I've been here. I know that when I was speaking to Deputy General Counsel Mark Green, he's not familiar with it either. So that's...
I'm at the front of the line. Forgive me for interrupting. I'm at the front of the line for expedient government action, typically. To let's move along, you know. But I'm picking up more of what you shared to begin with. That there needs to be some more information here gathered, and
it seems like I mean, if you read this, I would say you probably should have a subrogation agreement in the can. In other words, because it contemplates a subrogation agreement, so there should be a form there that says here's a subrogation agreement. But it's never happened before, so I wouldn't worry too much about precedent because every case is going to be different. I would think. We can sit here and spend 2 months trying to figure out what's going to happen in the future, and it won't, and the next case comes along, it's not going to be exactly fit in that box, and he's going to be back in the same, we're going to be back in the same situation with a different attorney wanting to tweak it a little bit for whatever the thing fits. So, I mean, that's just my opinion. So that's kind of why I'm wanting to move it on down the road. At least that's my motion.
Up to the amount that was withdrawn would be.
Yeah, or you could tweak. Yeah, that'd be an easy fix.
You know, the banter back and forth is interesting, but we're stuck with what the statute says.
Yep.
And as a creation of the legislature, we don't have the authority to change it. We don't have it. Right. So we're stuck with what the statute says. So if the risk is on the complainant for whatever amounts they're awarded, then that's the way the legislature wrote it. That's the way it's going to be enforced. And we don't have the authority to do anything about it. I don't know that the Attorney General does. I know counsel doesn't. So I think we're stuck with what the statute says. I'm not adversarial to the 4 claims. I'm not adversarial to giving it the $15,000 per, but after that, all we have is the statute. That's it. So subrogation agreement, all that kind of stuff, I think those are academic conversations that at the end of the day, we come back to the statute. Thank you, Mr. Chairman.
Hi, Jeff. Thanks. So we have a motion on the floor and subsequent discussion, but the motion at this point agrees that there are 4 different situations that each have incurred $15,000 worth of payment to Mr. Thomas's client. There's still the issue of the logistics of it. That's some bifurcation. He's talking about what the paperwork's going to look like, who signs it, who reviews it. Is that the Commission's understanding that if this motion passes, that we're only partially done with this case? Is that what you think, Joe?
I think that we've agreed to the 4 counts up to $15,000 per count, and then counsel and Mr. Thompson will be, if they agree on the paperwork, then I guess it's a done deal. Is that correct?
I just want to make sure that's the intent of the motion.
Yes.
That's what you're thinking?
Yes. It still, I hate to use subject to the 2 parties working out the subrogation agreement.
That's the intent.
That's exact. Yes.
I still submit there's nothing to work out. The statute says what it says. Period. If you don't like it, you got to go to the legislature and get them to change it.
If I may address that,
Mr. Chairman.
The rules of statutory construction provide that you have to read a statute as a whole. I think the clear. I mean, you know, if you want to read just that one section by itself, you're not reading it as a whole, and you're not getting the true legislative intent. And there's well-established rules of statutory construction that you have to read the statute as a whole in an effort to give the legislative intent. But
the legislature doesn't intend us to change the law in this body. The statute says what it says. I'm reading the statute as a whole. That is part of it. And it says that we can't enter into a separate agreement that goes against the law. We don't have the authority to do that.
And I would like the opportunity, if possible, to go back and get the legislative debate over the most recent legislative debate and add that to the record. And if we needed to postpone for another 30 days, we can do that.
So
you can do whatever you want.
Yeah.
We're here seeking your assistance.
All right, so the motion on the floor is to determine there are 4 events that each are entitled $50,000 and let the paperwork get worked out at a later date. Is there further discussion?
Yeah, I'm more of opinion that if there's 4, there's 5 transactions. That's why I didn't second the motion. But.
So, I'd like to make a substitute motion. DJ, you've got the floor.
I would not at this time like to make one. I would, if anything, I would move to table the discussion until the February meeting.
Got the floor if you'd like to do that.
I would move to table this discussion and my motion at that time, possibly to have 5 to award Ms. Gal 5 transactions. I move to we table. Let me start over. Time out. I move that we table this discussion until the February meeting.
Let's not call it table. There's some parliamentary connotations to that, but
that's what I was thinking. I was trying to get the motion involved in that, but
postpone until the February meeting.
Yeah, move to postpone to the February meeting.
Second. Second by Mr. Bagley. So that's on the motion. That's on the floor. Who was it? Diaz? I'm sorry. Second was by Jeff. So the substitute motion on the floor now, if it gets 4 votes, will cause this topic to show up on the agenda in February. If, on the other hand, there are not 4 votes for the motion, we'll go back to the primary motion, which is Steve and Joe's motion of 4 times 50 physically.
But do we not vote on that one first? But we don't?
Substitute motion always takes precedence. So, is there discussion on the motion to postpone for 30 days? So, I'm going to take a little personal privilege here. From the chair's perspective, I think it's a good idea. But I think it's a good idea primarily, not necessarily because it's going to go from 4 to 5, but because our council, and we're not in an adversarial position. It's not like the state's fighting you on it. The state just wants to make sure we get it right.
We're fine with it.
I got it. So I think given the council latitude to get it right and feel comfortable with this and say this is how we ought to go from now on is a smart move. So that's my comment on the thing. Any other discussion? Okay, we're going to vote on the substitute motion, which is to defer for 30 days. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. No. And that motion passes on a 6 aye, 1 no vote. Mr. Quinn votes no. Mr. Thomas?
Chair and members of the commission, thank you so much for your consideration.
So I don't mean to bias my decision next month, but I'd like to have you as my attorney someday, except you probably charge way too much, right?
We'll see how this case comes.
You're dealing with these $1 million clients. We'll see you next month. Thank you.
Thank you.
Anna, anything else to come before us on the legal front? We've got a caption down here called Commission Discussion. Do you have anything on that?
I do not.
I do.
Okay.
This is hard for real estate commissioners to remember, but we meet on a Tuesday in February. Not on Wednesday, but on a Tuesday. And the goal is to be done with that meeting, which Anna's already said is a one-day meeting, by noon. And those of you who wish to can go from here down to downtown Nashville and sit on a panel with the Tennessee Association, TUR, Tennessee Realtors, TUR, not TAR, with the full understanding there is absolutely no requirement that you go. It's not part of our function. We're doing it as a courtesy to them. Staff will be there. And there'll be questions about education, grandfathering, all kinds of things that we handle but people don't listen to. So make your plans accordingly. If you want to leave here at about noon next, whatever date that is in February, feel free to go. Feel no obligation to stay. But hopefully we'll have a quick meeting. I'll shut up a little bit more. We'll get out of here and we'll get home. Anything else? Okay. If not, Joe, anything to say on the way out? Jeff? Miss Bleeding Heart, Miss Torvett, I mean. Anybody? All the way around? All right, guys, we're adjourned. Be safe going home. Thanks for being here.
Yeah.